file is lying in this courtroom, my lord. I mentioned the matter.
No,
earlier.
was it fixed earlier?
No, I mentioned the matter for enlistment. Your lordship allowed the mentioning. After that, the file has come before this.
Anyway, let it appear as to be mentioned.
May I permit to mention, lordship, last occasion matters heard, lordship. Thereafter, lordship fixed this matter 20 July to 2 p.m. lordship. But 20 July, this matter is not appeared listed. But I take instruction from the court that matter appeared 2 p.m. supplementary, lordship. I have not followed this list, so matter is not.
Anyway, let it appear as to be mentioned. A date will be fixed. Yes.
My lord, may I?
Anyway, if the records are right, it will appear. Just a minute, yes.
My lord, may I have your lordship leave to mention a matter which has been assigned before your lordship? Your lordship has heard this matter on 3 occasions, but your
Which
lordship
petition?
heard it petition.
Yes, give it.
My lord, I am praying for a accommodation for the one day. Your lordship
Oh,
has
is it appearing in the list?
this has been fixed.
This matter not appear today. This
Tomorrow it will appear. So please mention tomorrow when the matter is taken up. So when the matter is taken up, please mention tomorrow. Yes. Application, yes.
My lord, may I be permitted to mention one matter for extension of the interim order, my lord? It will
Yes, to be
expire on
mentioned. Have you served notice to the other side?
We shall serve it during the course of the
My lord, may I be permitted to mention for correction order dated 22nd?
Yes, to be mentioned. Yes. Recalling application. It is not appearing in the list. It was heard earlier. Yes, give it.
may I have your lordship's kind leave to mention, my lord, an application for substitution in connection with the second appeal.
Yes.
Application for
Application for?
claim matter.
Give it.
Mention item number 23.
Wait, outside the list first. Yes.
So, lordship, for inclusion in the list. Section 5 application, lordship.
Section 5 application, yes. Yes.
My lord, for the inclusion in the daily list.
Inclusion under what heading?
My lord, CO number 3630 of 2019.
No, is it ready for hearing matter or admission?
For just inclusion, my lord.
No, inclusion under what heading?
Admission.
Yes, give it. Yes.
Lordship,
Yes, any other mentioning outside the list? Yes, inside the list.
Your Lordship, yesterday, item number 23, it was mentioned for correction. Your Lordship had been pleased to fix it at 4 p.m., Your Lordship. But the same is not fixed at 4 p.m. In today's list.
Okay. Yes, item 23. Let it 23.
23.
Yes, let it appear. Let this matter appear on 24/7/2026 at 10:30 a.m.
PM. Grateful, Lordship.
for correction.
Grateful, Lord.
Yes, call the list.
Mr. Amit Ranjan is appealing for the respondent claimants. I think Mr. Roy has filed some application.
What is this application? Can file? Application for?
Application, I think, in fact,
Item 66.
I think 66.
Yes.
I had 2 applications that section 5 stay. All applications were disposed of.
All are disposed. So this is for what? Can 5?
This application today is appearing that filed by Mr. Roy. For maybe
Anyway, not today.
My lord, I am appealing for the respondent, my lord. My lord, in this matter, I have mentioned the matter, my lord. My lord, they are not diligent, my lord, with the matter, my lord. They have filed
What are these applications? Can 2?
my lord, the can 6 I have received, that is the substitution application with the 53 days of delay, no delay cause has been
Anyway,
shown.
can 3,
Can 6, my lord.
can
six.
6, can 6 is not appearing. Yes. Can 6 is your application.
My lord.
Dekhi, can 6 টা আছে?
Can 6, I have stated the reason.
Okay, let me see.
The suit has been abated, my lord. 53 days of delay.
Six.
Have you got it? Can 6.
Yes.
But here, my lord, the appellant
So
number
when
one,
did this appellant die?
appellant number 1 died on
Okay.
23rd of October, October 2024.
The sole appellant?
No, there are other appellants.
No, which appellant? No.
Appellant number 1 died.
Appellant number, that is, yes, leaving behind?
Leaving behind the years, I have stated in paragraph 1. Legal years.
Yes.
Sons and daughter.
Yes, I'm recording your objection.
My lord, kindly see one.
Yes.
My lord.
But my lord, what happened? That deponent.
Yes, yes,
The
yes.
substitution application, who is from the Sahabuddin Molla.
Yes.
My lord, the appellant number 2.
Yes.
My lord, the appellant number 2, 3, and 4.
Yes.
They have allegedly sold the whole plot.
Anyway, you file an application for that.
The basis of that.
Yes, my lord.
Learned advocates for the, you are for all the respondents.
Yes, my lord.
Learned advocate for the parties are present. This application is filed for recording the death of appellant number 1, Muhammad Ikhtiaruddin, alias Ikhtiaruddin Ali Ahmad Mullah, the appellant number 1 hearing. It is the contention of the applicants that appellant number 1 died on 23/10/2024, leaving behind the applicants as the legal heirs. Learned advocate appearing for the respondents opposes the application on the ground of delay. Stop. Upon considering the petition and the grounds furnished for the delay, this court is of the view that delay should be condoned and the application for substitution should be allowed. Thus, delay in filing this. Yes.
I'm so sorry, madam. But the order 22 rule 9 was any application has not been preferred.
Anyway, the prayer consists what? Substitution.
Yes,
What is the prayer?
Milord, madam.
Yes.
But the suit has been abated, Milord.
Yes.
That's why
Just a minute.
I have also filed
Application is condoned and the application for substitution stands allowed and abatement, if any, is set aside. Let the name of the appellant number 1 be deleted and the name of the applicants as mentioned in para 1 of the application be substituted in its place and stead. The
Well,
department,
here.
the department to carry out the amendments within 2 weeks.
Well, here I want to say, I think
Yes.
my learned will not object.
Yes.
Let the main appeal be placed for hearing.
Let it come up after 2 weeks, okay?
Fixed, my lord.
Let the amendments be
One point involved.
let the amendments be carried out. Yes, liberty to mention.
Milord, to
For early hearing.
Liberty to
Well,
mention
liberty
after
to-
2 weeks.
liberty to mention to all the parties. my
Yes,
lord.
yes. Paper books are ready.
Everything ready.
Okay.
It was hard in my.
Okay, after the amendments are carried out, after the amendments are carried out, mention after 2 weeks.
Justice Chaudhary.
Obliged.
नहीं কিছু নেই।
Excuse me, देखिए एकटू. I'm appearing on behalf of the respondent insurance company. My lord, Mr. Amit Ranjan Rai is
This
appearing.
is application.
He is appearing online. Tanta কিসের আছে? It's for recording of majority. কোথায় online নেই?
देखिए application stack.
This is under section 168.
Oh, So let this application be disposed in his absence. देखिए ये करता
হ্যাঁ ওই তো আছে না নেই জানি না
applicants number 2 and 3. That is the appellants number 2 and 3. You have the copy of this application?
কপি appellant number 2 and 3
Yes, record an order. Learned advocate for the respondent insurance company is present.
I am also present, Lordship.
Learned advocates for the parties are present. The application CAN 2 of 2026 is taken up for consideration. This is
My
an
lord,
application.
I'm
Yes.
sorry. This can be disposed of. If my lord is kind enough to take it up at 2 today also.
Just a minute. So it's better.
Lordship.
It's better I take it up, take the entire matter.
Yes. Because one matter,
Let me see whether there are any fixed matters or not.
yes, one matter which is fixed at 3 o'clock, my lord. That my lord had made CAV. That is of my learned senior friend, Mr. Singh. So, না মানে ওটা বেরিয়ে যাচ্ছে তাহলে আমারটা হয়ে যেতে পারে আরে 2 মিনিট লাগবে it will only take 5 minutes.
Okay, let it be called on at 3 p.m.
I'm grateful, my lord, deeply.
I'm grateful, Lordship. Lordship, item number 66, Lordship, again, not this week, Lordship. 66, I fails to appear.
Please wait.
66, Mr. Sanjay Pal is appearing.
Yes.
Please make it not this week, my lord.
Okay.
I'm asking for the respondent claimant.
I'm on behalf of the appellant insurance company.
Whose application is this? CAN 3?
So I filed one application, this is CAN 3. There is assignment of majority of claimant respondent number 2, your lordship.
কি দিচ্ছেন এই তো আমাকে দিয়েছেন তো এই যে এইটা তো এই যে হ্যাঁ ঠিক আছে CAN 3
Hello. Tribune করেছে।
না
Okay, appellant number 1.
Appellant, majority of
Oh, sorry. This is the respondent number 1.
respondent number 2, majority of
Respondent number 2.
বিভক্ত তো দেয়া যায়।
Yes, record. Learned advocates for the parties are present. The application CAN 3 of 2025 is taken up for consideration. Heard learned advocates. The applicant, respondent number 2, has filed this application for recording his majority. It appears from record that the said appellant has attained majority on 29/10/2021. Stop. The Aadhaar card is also annexed with the said application. Thus, this application stands allowed. Let the majority of respondent claimant number 2 be recorded. The department to carry out the amendments within 2 weeks, liberty to mention.
Your lordship, this matter, your lordship, the paperwork has been filed and served upon my learned friend, your lordship.
Okay.
The matter is ready there.
Mention after 2 weeks. I shall take it up.
The matter was appearing in the hearing list, your lordship.
Anyway, on the next day, mention after 2 weeks. I'll take it
Filing
up.
the paperwork. Your
Acha, let the paper books file be kept with the record and copy be served.
I have already served.
Okay.
grateful, my lord. Liberty to
Your
mention.
lordship, liberty to
Yes,
mention
liberty to mention.
after 2 weeks, your lordship. Liberty to mention after 2 weeks.
71, my lord, will kindly make this not this week. One
Respondent number 3.
respondent number 3 has expired, my lord. Let it retain its position.
Okay, not this week.
My lord, my lord. Retain, my lord.
Thank you, my lord.
72, my
I am
lord.
for the
I am appealing
appellant,
for
my
the
lord.
respondent claimants.
My
my
lord,
lord.
paper book file, my lord, matter is ready for hearing, my lord.
What is this can 3?
Can 3, my lord, an application for additional evidence under order 41 rule 27, my lord. In this application, wherein noted, my lord, the disability certificate where issued by the claimants, my lord, under prescribed by the board of medical board of Nadia district, my lord, wherein noted, my lord, permanent disability %. And my lord, in the pendency of the during the pendency of the claim petition, wherein issued disability certificate, wherein noted 50% but basis. During the pendency of the appeal, instant appeal, my lord, issued medical disability certificate 50% disability, my lord.
This is this application for
Yes.
requesting additional evidence.
Yes, my
So
lord.
one thing can be done. The matter can be remitted back to the trial court. Let the evidence be recorded and let the matter file be sent after 1 month. That can be done. So
During the pendency of the claim petition, wherein, my lord, on the temporary basis,
order 41 rule 27, you see, the matter can be remitted to the trial court to take necessary evidence on this issue. Anyway, let this application will be taken up along with the appeal. Yes, record an order. This is an application under order 41 rule 27 of the Code of Civil Procedure. Rule 27 of the Code of Civil Procedure. Let this matter be taken up along with the hearing of appeal. Paper books are ready.
already filed, my lord.
As the paper books are filed, let this matter appear in the list after 2 weeks.
Well, kindly pick the date and
So I'm keeping it after 2 weeks in the list. Thereafter, I shall fix a date.
hearing list.
Yes, under the heading hearing.
Hearing.
This matter I am appealing for the petitioner, Your Lordship. There are 3 applications filed, Your Lordship, here. Lordship, copy to be short there, even everything. Lordship, before proceeding with the application, Your Lordship, just telling what happened, Your Lordship. The accident took place, Your Lordship, on the 5th December. Now, vehicle was seized 2 months thereafter. Along with the vehicles, Your Lordship, the seizure list, Your Lordship, the policy was there. That copy of the policy was served upon the claimant's advocate. Now he filed the claim application. Now what happened, Your Lordship? The date of the accident, the vehicle was insured with Cholamandalam. But thereafter, on the renewal day, Your Lordship, it was insured with the New India Assurance Company. So, Your Lordship, the matter proceeded as if the New India Assurance Company is the respondent. The defect was pointed out at the time of the evidence and thereafter. So, the claimant's appellant filed an application for amendment of the claim petition.
Before the trial court?
Before the trial court. Now, the claim application, that application was taken up for hearing. The learned judge, what happened, first the order without, the application is disposed of without any order. Thereafter, matter was taken up for hearing and the judgment was delivered against the owner. Without considering the vehicle was insured with Cholamandalam. The defect, Your Lordship, that...
Now all the insurance companies are before this court. Cholamandalam and United.
Cholamandalam, I've served the copy, I have served the application.
Yes, who appears for Cholamandalam?
I'm appearing, my lord. I'm appearing.
Both the insurance companies.
My lord, your lordship, can you take up this matter, my lord, tomorrow? My lord, today my documents.
Let the matter be heard out on a particular date. Entire matter, if the paper books are ready.
Your lordship.
Let the entire matter be heard out. So you are ready to appear for both the insurance companies. Yes, record an order. Learned advocates for the parties are present. The applications filed are taken up for consideration. Heard learned advocates. As this matter is ready for hearing, this court is of the view that the entire appeal should be heard out. As one of the insurance company is not before this, one of the insurance company, namely Cholamandalam.
I'm there, my lord. I shall.
No, I'm just mentioning. Name of the insurance, Cholamandalam?
Cholamandalam and New India Assurance.
Cholamandalam, MS, General Insurance Company Limited, is not represented in this court. Mr. Singh, who appeared. Learned advocate for the appellant and learned advocate for the respondents' insurance companies are present. Fresh code order. Hard learned advocates on the applications. Upon hearing the application, this court is of the view that as the appeal is ready for hearing, the appeal should be heard out. Let this appeal appear for hearing on. দেখুন তো
Milord, after first week of August, Milord, one of his matters is fixed with me on 7th or 8th. After that, Milord, any day.
10/8.
8 is
10th of August.
8 is Saturday, your lordship.
10th of August.
10th.
10th August.
10th of August 2026 at 3 p.m.
See.
Milord, appeal we heard along with all applications.
Your lordship.
Entire appeal.
Because applications are pending, Milord, because that should not get any confusion. Appeal with applications.
So the appeal will be heard out with the applications.
Your lordship, I will prepare the paper book, your lordship.
Oh, you have not yet prepared?
I prepared, already prepared. I will serve the copy.
Okay, you have prepared.
I'll
Not yet filed.
On the date of the hearing, I will file.
Okay.
My Lord, will kindly pardon me in item number 6970, my Lord. I had can 2, it had not been disposed of. My Lord will kindly see order dated 29th of April 2024. But by mistake in the website, it's showing that it has been disposed
Can
of.
2 is for what?
Additional evidence.
So it will be taken up along with the appeal.
But if it shows disposed of 6970, can 2 ta dispose hoyni. Ota can 3 ta onar, can 2 amar. Server shows
can 3 for?
Can 2 for addition, can 3 for record attainment of majority.
The one in which my lord had just now passed order. Can 2 it has not been disposed of.
69 আর 70 তে একটা order লিখে নিন, হ্যাঁ? As can 2 of 2025 is not 24 is not disposed, the said application will be heard out along with the appeal.
My lord, I'm extremely grateful, my lord.
In opposition to that application, lordship.
Which application?
To can 2.
To can 2.
No, can 2 is your application.
It's my application for additional evidence. He wants to file
the affidavit in opposition filed to can 2 of 2025 is kept. Can 2
of 2024.
2024 be kept with the record.
I'm extremely grateful, my lord. Deeply obliged.
May I please, Your Lordship?
I'm for the respondent.
Well, there is 126 days delay. And
can 1 is for condonation of delay.
Condonation of delay.
How many days?
126 days, madam. As per my calculation. And my lord, may paper book
Yes,
may be
record an order.
may paper book may
Learned
be
advocate
accepted.
for the parties are present. The application for condonation of delay is taken up for consideration. Our learned advocate for the appellant and learned advocate for respondent number one
All matter
insurance.
for enhancement, my lord. kindly
Respondent
please.
number one insurance company. Upon considering the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is furnished for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. As the respondent number one, New India Assurance Company Limited is represented, service of notice upon respondent number one is dispensed with. However, service be effected upon respondent number two,
Not
both by
My lord, may not be
necessary
sorry.
because the owner of the vehicle did not contest the case before the learned tribunal, and this matter relates to only quantum
Is
of
it with regard to involvement?
no,
Only.
quantum of
Acha,
compensation. They have filed for enhancement.
as the respondent number two did not contest before the trial court, service of notice upon respondent number two is also dispensed with. The trial court records be
My lord, paper book is ready, my lord.
the paper book
my lord,
filed
very small matter, my
be
lord, kindly
kept with the record.
and
the-
any dates are convenient to your lordship, my lord.
The paper books filed be kept with the record. Let this matter appear for hearing on 1/8/2026. 11/8/2026.
At Malad?
At
11.
time, my lord.
11/8/2026 at 3 p.m.
Within application formula incorporating additional ground. AC can AC malad AC paragraph 3.
Oh, are accepting 80% instead of 50%. Yes, what do you say? This is the ground of appeal, not additional evidence. This is the point of law. What they have not taken in their memo of appeal, they want to incorporate it in this additional ground. It's not that they want to adduce evidence. Have you filed any opposition to this? Okay, yes, record an order. Learned advocates for the parties are present. Her learned advocates peruse the petition filed. The petitioner appellant has prayed for incorporating an additional ground that the learned, which is as follows. The quote eta hai for that theke. Stop. Although learned advocate for the respondent claimant opposes this application, but considering the nature of the case, this court is of the view that the additional ground should be allowed. Thus, this application stands allowed.
Incorporated by the department or by hand.
The necessary amendments be carried out by the department within 2 weeks. Liberty to mention.
The matter may be appeared to be mentioned.
After 2 weeks, you mention?
Six. 76, my lord. I am for the appellant. There are 3 cans, my lord. One is for delay application, condonation of delay application. One is stay application, and another is amendment application, reliance, my lord. And this is the
Amendment of what?
reliance, my lord.
Oh, that
And there is,
service upon the opposite parties are complete.
yes, affidavit of service. Can 1, can 2.
Yes, first this application for this substitution be carried out. Thereafter, the other applications.
My lord, stay application has to be.
No, the substitution has to be carried out. Otherwise, it will be defective. First, get yourself incorporated. Thereafter, you move the matter. থ্রিটা হলেই হবে। Yes, record an order. Learned advocate for the applicant is present. This is an application for substitution filed by the applicant to substitute itself in place and stead of the appellant, Reliance General Insurance Company Limited. Stop. It is the contention of the applicant in the Sindh General Insurance Company, in the Sindh, UNDUSIND, General Insurance Company Limited, that the appellant has merged with the applicant and is known as Indasin General Insurance Company Limited. The certificate issued by the Insurance Regulatory and Development Authority of India is also annexed. Stop. Thus, the application stands allowed. Let the name of the appellant, Reliance General Insurance Company Limited, be deleted, and the name of the applicant, Indasin, INDUSIND, General Insurance Company Limited, be incorporated in its place and stead. The department to carry out the amendments within 2 weeks.
My lord, 1 week, because there is a stay application, my lord. Kindly direct the department to do it within 1 week, my lord. Kindly, my lord.
Acha. There is any execution case? When is the execution case? Stay means there has to be an execution
That
case.
was passed on 25/9/2025. After that, these amendment application has to be done. It is so late. We do not have the exact status of the lower court, my lord.
As the matter is sub judice before this court, the necessary prayer may be made before the trial court for adjournment, which may be considered.
My lord, I'm extremely grateful.
My lord, I'm for the appellant in this matter, your lordship. I'm filing the affidavit of service and the statutory deposit has already been paid.
Appellant Insurance Company?
Yes, sir.
Yes. Yes, learned advocate for the appellant insurance company is present. None appears for the respondents in spite of service of notice. Stop. The application for condonation of delay is taken up for consideration. Our learned advocate for the appellant peruse the petition filed. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that sufficient ground is furnished for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. The application for stay being Can 2 of 2026, Can 1 of 2026 stands disposed. The application for stay being Can 2 of 2026 is taken up for consideration. Stop. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 6 June 2025, passed by learned additional district judge, Second Court Shuri, in MSCC number 69 of 2013 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire compensation awarded by the learned trial court, entire compensation amount along with interest as directed by the learned trial court within 5 weeks from date. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. Notice be served upon the respondents personally by registered post as well as through the department by filling up necessary requisites and forms. The trial court records be called for at the special messenger cost of the appellant to be deposited within 2 weeks, and the paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
Lordship, I am
Yes.
Appellant Insurance Company, Your Lordship. I am filing the affidavit of service and the statutory deposit has already.
Learned advocate for the appellant insurance company is present. None appears for the respondents in spite of service of notice. The affidavit of service file be kept with the record. The application CAN 1 of 2026, which is filed for condoning the delay in preferring the appeal, is taken up for consideration. Stop. Heard learned advocate for the appellant. Peruse the petition filed. Upon perusing the petition filed and upon hearing the learned advocate, this court is of the view that sufficient ground is furnished for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. The application for stay being CAN 2 of 2026 is taken up for consideration. Stop. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 11 June 2025, passed by learned additional district judge, special court, EC Act, come additional district judge. আচ্ছা, additional district judge না, এটা করে দিন, learned judge, special court, EC Act, come additional district judge, special court, come additional district judge, Paschim Medinipur, in MSC case number 373 of 2019 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. The appellant insurance company shall cause service of notice upon the respondents, both personally through registered post as well as through the department by filling up necessary requisites and forms. The trial court records be called for at the special messenger cost of the appellant to be deposited within 2 weeks. Stop. The paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
Lordship, I am for the Appellant Insurance Company, Your Lordship. I am filing the affidavit of service and the statute. It's a business.
Yes, learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. Stop. The affidavit of service file be kept with the record. The application for condonation of delay being CAN 1 of 2026 is taken up for consideration. Heard learned advocate peruse the petition filed. Stop. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that sufficient ground is furnished for condoning the delay. Stop. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Next. The application for stay being CAN 2 2026 is taken up for consideration. Stop. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 12 June 2025, passed by learned additional district judge, 7th Court, Purbo Medinipur, in MSC case number 518 of 2021 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. The appellant insurance company shall cause service of notice upon the respondents, both personally through registered post as well as through the department by filling up necessary requisites and forms. The trial court records be called for at the special messenger cost of the appellant to be deposited within 2 weeks. The paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
Lordship, I'm for the appellant insurance company. Lordship, I'm filing the affidavit. 80 mine.
Have you filed the affidavit of service?
Yes, 80 is my appeal. 80, sorry. 81, Lordship, it's
81, okay, just let 80 be taken up.
81 হবে 80
এটা কত 80টা দিয়েছেন তো?
আমার 80টা।
Yes, 80. Reliance versus Ankita Bhattacharya.
81 হবে।
You filed the affidavit of service.
My lord, there is no delay, my lord.
No, this is CAN 1 of
CAN
stay.
1 is stay and CAN 2 is amendment application, Reliance.
Okay, CAN 2
Same
be taken
order
up.
as 76, my lord.
CAN 2, record an order. Learned advocate for the appellant is present. The application for substitution being CAN 2 of 2026 filed by the applicant is taken up for consideration. The applicant in the instant application has contended that the appellant Reliance General Insurance Company Limited has merged with Indus-Sind General Insurance Company Limited. Stop. The certificate issued by Insurance Regulatory and Development Authority of India is also annexed. Stop. Thus, this application for substitution stands allowed. Let the name of the appellant be deleted from the cause title and the name of the applicant in the Sind General Insurance Company Limited be substituted in its place and stead. The department to carry out the amendments within 2 weeks.
1 week, my lord. Stay application is there, my lord. Same order as 76, my lord.
As the matter is sub judice before this court, the parties may seek adjournment before the learned trial court, which may be considered.
I'm extremely grateful, my lord.
Statutory toll file has order. Lordship, I'm for the appellant insurance company. I filed the affidavit of service and the statutory deposit has already been paid. Statutory toll.
Yes, record an order. Learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. Stop. The affidavit of service file be kept with the record. Stop. The application Can 1 of 2026 is taken up for consideration. Stop. The appellant in the said application has prayed for condonation of delay. Upon hearing the learned advocates and upon perusing the petition, this court is of the view that sufficient ground is furnished for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. The application for stay is being Can 2 of 2026 is taken up for consideration. Stop. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 6th March 2025, passed by the learned Additional District Judge, First Track 5th Court at Barashat, North 24 Parganas, in MSC case number 37 of 2018 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. The appellant shall cause service of notice upon the respondents, both personally through registered post as well as through the department by filling up necessary requisites and forms. Stop. The trial court records be called for at the special messenger cost of the appellant to be deposited within 2 weeks. Stop. The paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
$83 million is the insurance appeal as bring for interim stay. May I file the affidavit?
So there is no delay.
There is a delay. There is a delay of 41 days. But my affidavit of service and the deposit receipt is forwarded to your lordship.
Yes, record an order. Learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. Stop. The application for condonation of delay being Can 1 of 2026 is taken up for consideration. Heard learned advocate for the appellant. Peruse the petition filed. Stop. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is furnished for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. The application Can 2 of 2026 is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 26th day of September 2026, passed by learned Additional District Judge, First Track 2nd Court, Barhampur, Murshidabad, in MSC case number 726 of 2015 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks.
Not less statutory deposit.
Anyway, that is implied. I mean, other orders also have not passed that.
My lord, earlier my lord used to always mention, my lord, less statutory deposit because that is already being made before your lordship. My lord. In all earlier orders, my lord, it was
The entire compensation amount shall exclude the statutory
grateful to
deposit.
my lord.
Because you see, in one order I pass, there shall be excluding statutory deposit. In the other order I don't
Lord,
pass.
in
That
all-
will create problem.
In each one of my lord's earlier orders, still
No,
date,
today also I have passed.
my lord,
certain
today, my lord, but barring that, my lord, all earlier orders, this word less statutory deposit was always there. Less statutory
ওই
deposit.
আগের গুলো তো
Lord,
সবই
let in other matters also let that be added, my lord, to
হ্যাঁ।
avoid any confusion.
ওটা একটু বলে দিতে হবে, বলে দেবেন তো
Less
আচ্ছা,
statutory
এই
deposit.
অর্ডারের মতো করতে আর কি।
My lord, may I just, my lord, the last line, your lordship, one of my lord's order, in all orders it was there.
No, because you see there should be parity, but because otherwise they will face problems.
Yes, in other orders.
One order
I understand.
excluding the other.
My lord, that is why I say, in all other orders, your lordship.
আচ্ছা
will kindly
ওইটাতে
add
একটু
this
করে
line.
দিতে বলবেন, হ্যাঁ, এক্সক্লুডিং মানে স্ট্যাচুটরি ডিপোজিট।
Yes.
আচ্ছা, entire compensation amount along with interest as directed by the learned trial court excluding statutory deposit
Grateful to your lordship.
within 5 weeks from date. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. The appellant shall cause service of notice upon the respondents, both personally through registered post as well as through the department by filling up necessary forms and requisites. The trial court records be called for at the special messenger cost of the appellant to be deposited within 2 weeks. Stop. The paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
My lord, my lord has given the order for, to my lord's officer for investment, my lord.
আচ্ছা ওই এই the
To the
registrar
Registrar
general is requested to invest, ওটা একটু মাঝখানে দেবেন, to invest the statutory invest the compensation deposited in a fixed deposit of a nationalized bank and renew the same from time to time.
Extremely grateful.
অন্যগুলো
to
তো
your lordship.
বলে দেবেন।
Yes, 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 in all matters. I'm obliged to my lord.
'84, my lord, I am appearing on behalf of the appellant insurance company. I have deposited 25,000. There is no delay. This is the copy of the challan. My lord, the lower court records, my lord, I have the entire set. For the timing, my lord will kindly dispense it. It's from Alipur.
It becomes difficult to see. Sometimes problem arises. One document is incorporated, one is not incorporated.
I appreciate, my lord. It's from Alipur. For the
It will
timing,
not take much time.
it won't take my, for the timing, my lord will dispense with. If it is needed, my lord will call for it at a later stage.
Learned advocate for the appellant is present. The application for stay is taken up for consideration. Hard learned advocate, produce the petition filed. Stop. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 27th day of January 2026, passed by learned additional district judge, first track 7th court Alipur, South 24 Parganas, in MSC case number 758 of 2021 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount, within 5 weeks. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The appellant insurance company shall cause service of notice upon the respondents, both personally through registered post as well as through the department by filling up necessary forms and requisites. The filing of informal the trial court records is dispensed with at this stage.
My lord, grateful,
Stop.
my lord.
The informal paper books be prepared within 4 weeks. Liberty to mention.
I'm grateful, my lord, deeply obliged.
ওটা রেজিস্টার জেনারেল, ওটা করে দেবেন, ঠিক আছে?
85. Lord, 85 is insurer's appeal appearing for the first time. Lord, I was praying for interim stay. Lord, I made a statutory deposit. Lord,
So there is no delay.
There is delay. It appeared since.
Affidavit of service, it has returned or what?
Lord, it has returned, my lord. The postal department says that the detailed address is not given. And my lord, in my
the claimant as the vehicle or not?
Yes, my lord, in my affidavit of service, I have written down that the address given in the claim application has been incorporated in the service. That is written in my application, my lord. And in my
other
affidavit of
cases, it was not returned, it was served.
Yes, it was in another case, it was served. My lord, I'll serve them again.
Learned advocate.
Your lordship will kindly condone the delay and grant
for the appellant insurance company is present. affidavit of service filed by the appellant insurance company be kept with the record.
I can one.
It appears from the returned envelope that there, due to insufficient address, the service could not be affected. Stop. As the service was affected in the addressed as mentioned in the cause title of the claim case,
Lordship.
but it could not be affected, the service upon the respondents is dispensed for the time being only with regard to condonation of delay application. The application for condonation of delay is taken up for consideration. Hard learned advocate for the appellant peruse the petition filed. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that sufficient ground is furnished for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. So, cause service with regard to stay once again?
Yes, my lord, I shall. No, my lord, your lordship is granting me interim stay till disposal.
No, actually, the thing is this stay application. Because you
Milord,
see,
I shall, Milord,
section
Milord,
5, I am condoning.
Your lordship is condoning the section 5. Milord, I shall be depositing the entire awarded sum before my lord's court. Stay application would remain pending, and in the meantime, I'll serve them again, Milord.
The application for stay is taken up for consideration.
Because I have served stay as well as condonation, both.
Hard learned advocate for the appellant. Stop. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 4th day of December 2025, passed by learned District Judge Nodia in MSC case number 300 of 2018 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Let service of this application for stay be once again effected upon the respondents. Let this matter appear after 4 weeks.
Milord, after 6 weeks, because your lordship is granting me 5 weeks time to deposit.
After 6 weeks.
After 6 weeks. Grateful to your lordship, Milord. Milord, 86 is also similar application, Milord. I made the statutory deposit. Here, Milord,
it has returned.
Owner has received, but Milord, as far as the claimants are concerned, it has come back, Milord, with remark that insufficient address. Whereas, Milord, I have written that in the claim application, whatever address was given, I have served there. It is there in my cause letter. Milord, the address which is provided, Milord, in the claim application, Milord, I cannot have any better address than that. It is just activity.
Learned advocate for the
stay is written.
Appellant is present. Heard learned advocate. Learned advocate for the appellant is present. The affidavit of service filed by the appellant reflects that service could not be affected upon the respondent number 1.
Milord, 1 to 4 are the claimants.
1 to 4. 1 to 3.
Milord, 1 to 3, yes. 1 to 3 are the claimants, yes.
1 to 3.
It has come back with remarks, insufficient address.
1 to 3.
Lordship.
As the service could not be affected upon the said respondents due to insufficient address. Stop. It is contended in the affidavit that the notice was sent to the address mentioned in the claim case.
Lordship.
In the facts and circumstances, the service of notice is dispensed with for the time being with regard to the application for condonation of delay and the application for stay. Upon perusing the application for condonation of delay, it appears that the appellant has furnished sufficient ground for condoning the delay. Thus, delay in preferring this appeal is condoned. and the appeal is admitted. The application for stay being Can 2 of 2026 is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 27 November 2025, passed by learned Additional District Judge, 17th Court, Alipur, in MSCC number 58 of 2016 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire compensation awarded along with interest as directed by the learned trial court, excluding the statutory amount, within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Let this matter appear after 6 weeks. The appellant insurance company shall once again cause service of notice upon the respondents number 1, 2, and 3.
Lord, the direction for investment, Lord, again, your Lordship.
ওইটা করে দেবেন রেজিস্টার জেনারেলের ওটা।
Obliged, your Lordship.
So once again it will appear after 6 weeks.
Yes. Grateful to you.
It is I'm for the appellant, my lord. There are two applications, one for condonation of delay and one for stay, my lord. My learned friend is appearing for the claimants number 1 and 2, my lord. And will condone the delay and for the interim orders stay. One condonation of delay and two stay.
We have filed a cross objection, my lord.
And আগে direction গুলো হোক, then.
Yes, record an order. Learned advocates for the parties are present. Learned advocate for the appellant and learned advocate for the claimants, respondent number 1 and 2 are present. Stop. So respondent number 3 is not represented.
Not represented.
Have you filed affidavit of service?
No, since Mr. Malad is appearing for the Malad.
However, service of notice upon the vehicle owner respondent number 3 is dispensed with at this stage. The application for condonation of delay is taken up for consideration. Our learned advocates perusing the petition filed. Upon perusing the petition filed and upon hearing the learned advocates, this court is of the view that sufficient ground is furnished for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. The application for stay is taken up for consideration, being Can 2 of 2026. Stop. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 19th May 2025, passed by learned Additional District Judge, 2nd Court, Asansol, in MSC case number 6 of 2021 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory deposit, within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. As the respondents number 1 and 2 claimants have are present in court, service of notice upon the said respondents is dispensed with. Stop. However, service be effected upon respondent number 3, vehicle owner, both personally through registered post.
Through department.
No, both personally through registered post as well as through department by filling up necessary requisites and forms. The trial court records be called for at the special messenger cost
Not
of the
usual.
No. Why is not special? Otherwise, it will delay. Special messenger cost of the appellant to be deposited within 2 weeks. The paper books be prepared on arrival of the trial court records. liberty to mention after 6 weeks.
Quite a cross objection.
Let the cross objection filed by the claimant respondent be listed along with this appeal. Give the number. ওই নাম্বারটা লিখে দেবেন।
Milord 88, Milord, is the insurance appeal. Appearing for the first time, Milord, I was praying for entry mistake. May I file, Milord, this deposit receipt?
So same case, returned envelope.
Milord, in this case, Milord, my
Track report you have received.
Oh, Milord. Milord, it says, Milord, that the respondent numbers 1, that is the claimant. Milord,
Yes.
it has come back that for the reason addressee left without instructions. It went there, but Milord, addressee is not there, so it could not be served. But as far as Milord, the other respondent owner is concerned, that has been served.
So far, interlocutory applications are concerned very well, but otherwise, you see, you have to take steps for effective service.
Milord, I'll do that again.
At the prior to hearing of the
Since
appeal.
my Lord is keeping the stay pending.
Otherwise, you see, when you go before the trial court, when execution case starts,
Yes.
thereafter they will come to know.
Yes.
That is the time
Milord,
they
in
will
this
come
case,
to know.
Milord, the moment the stay is granted, they will come to know.
From the trial court.
From the trial court or whichever way, Milord, they will, because their advocates would know, Milord, the stay has been granted. They are
Unless you go to the trial court, you cannot ascertain.
Yes, Milord, when it is not served upon the claimants, Milord, the moment, Milord, they go before the execution, Milord, because we shall be informing this stay to the court below. And the Milord, the trial court, Milord, through trial court, they will come
Through trial court, they will come to know.
Yes, Milord. So the next day they will appear. Invariably, they will appear. Once my Lord stays there, next day they will appear. That is for sure.
Yes, learned advocate for the appellant is present. The affidavit of service is filed stating that the envelope returned on the ground that the addressee, claimant respondent number 1 has left. Stop. With regard to respondent number 2, the vehicle owner.
Yes, Milord, the service has been affected.
Service has been affected.
Lordship.
However, considering the facts and circumstances of this case, service of notice upon the respondent number 1 claimant is dispensed with at this stage. Stop. The application for condonation of delay is taken up for consideration. Our learned advocate peruse the petition filed. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is furnished for condoning the delay. Thus, delay of 11 days in preferring this appeal is condoned and the appeal is admitted. The application for stay being Can 1 of 2026 is taken up for consideration. Our learned advocates peruse the petition filed. Stop. As the appellant insurance company has deposited the statutory amount of ₹25,000, there shall be an ad interim order of stay of the judgment and award dated 11 December 2025, passed by learned Additional District Judge, 9th Court, Alipur, South 24 Parganas, in MSC case number 7 of 2014 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory deposit within 5 weeks. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Let this matter appear after 6 weeks. The appellant shall cause service of this application for stay once again upon the respondent number 1 claimant. The Registrar General, High Court, Calcutta, is requested to investigate.
Obliged to my Lord. Yes.
Earlier matter, kindly direct the Registrar General to invest the matter.
That will be done. So, আগেরটা তো করে দেবেন সবগুলো।
Milord, next matter is also identical, Milord. In this case, the claimants have received and the owner, Milord, he has refused.
Is there any dispute with regard to involvement of vehicle?
Yes, Milord. Yes.
So his service has to be affected.
He has refused.
Oh, refusal is a good service. Let us see.
Claimants have received.
But involvement of the vehicle is disputed.
My lord. Not only in any event else, my lord, when notice of appeal goes, in any event with another service is required to be given. From the department also it is.
Learned advocate for the appellant insurance company is present. None appears for the respondent number 1, 2, 3, 4, and 5 in spite of service of notice. Stop. The envelope with regard to notice of respondent number 6 has returned with the remark refused. Stop. As refusal is a good service, the application for condonation of delay is taken up in the absence of the respondents. Stop. Heard learned advocate for the appellant peruse the petition filed. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that sufficient ground is furnished for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. The application for stay being
Can
1.
Lordship.
ওটা আগেরটা can 2 হয়েছে. 1 of 2026 is taken up for consideration. Stop. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 29th day of November 2025, passed by learned additional district judge, second court Asansol, Poschim Bardhaman, in MSC case number 11 of 2015 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount within period of 5 weeks. Stop. In the event the entire statutory amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. The appellant shall cause service of notice upon the respondents, both personally through registered post as well as through the department by filling up necessary requisites and forms. The trial court records be called for at the special messenger cost of the appellant to be deposited within 2 weeks. The informal paper books be prepared on arrival of the trial court records. Liberty to mention after 6 weeks.
Lord, in case the amount is deposited, the interim order of stay will continue till disposal of the appeal. In this
till disposal of this application.
My lord, stay my lord is disposing of today.
No,
because service is effective. In this case, service is effective.
Okay. Till disposal of this appeal.
I'm grateful to your lordship, my lord. Extremely obliged.
But there is only one application that is must stay, my lord. That is within time, my lord. Stay, my lord.
Yes, learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 21st February 2026, passed by learned additional district judge, first track, 7th court Alipur, South 24 Parganas, in MSC case number 292 of 2017 for a period of 5 weeks.
As well as money execution case number 54 of 2026.
Have you stated that?
Not because, my lord,
just a minute. The appellant insurance company shall deposit the entire awarded sum along with interest. Shall deposit the entire awarded sum. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding statutory deposit within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. The appellant shall cause service of notice upon the respondents, both personally through registered post as well as through the department by filling up necessary requisites and forms. The trial court records be called for at the special messenger cost of the appellant to be deposited within 2 weeks. The paper books be prepared on arrival of the trial court records. Liberty to mention after 6 weeks, as the judgment and order passed by the learned trial court is stayed, there shall be a stay of the execution proceedings pending before the learned trial court for the,
That is MSCC execution case number
being MSCC execution case number
54 of 2026.
54 of 2026 for the period mentioned above.
Grateful.
Grateful.
So,
91.
91.
Item number 91, Your Lordship. I'm extremely, I'm apologetic for appearing virtually. Your
Yes.
Lordship, I'm appearing for the appellant claimant.
Yes.
Now, in terms of the last order, Your Lordship was pleased to allow my condonation of delay application. And we have served it on the other side, Your Lordship. My juniors will file the affidavit of service to show effective service being made on the parties. Now, Your Lordship, for the purpose of hearing, if Your Lordship would take it today, I am prepared. Or if Your Lordship can also give us direction to file necessary documents. Your Lordship, this appeal arises out of an order.
The books ready.
That is where my only request for Your Lordship's guidance.
No, this application is for what?
Yes, Your Lordship, this appeal is arising out of an order which has dismissed my application for restoration of the MSCC suit.
Paper books can be dispensed with.
No, my lord, no.
Your Lordship, the entire order has been passed on the basis of the conduct of the petitioner. That is the claimant, Your Lordship. So,
Very
Your
well.
Lordship.
The appeal be heard out.
Yes, Your Lordship.
If you prepare the paper books, the appeal will be heard out.
Now, my only request is only one request, Your Lordship. For the purpose of hearing whether this should be restored or not, the order, all the orders, an application is only required. Can we file a convenience compilation?
It's okay. Let the paper book be prepared. I shall take it
Grateful.
after 4 weeks.
Grateful, grateful.
I've got instructions to appear, my lord. My client would not forward me the documents. If I may receive the documents, my lord, whatever they have, the applications,
No, the
whatever.
question is with regard to preparation of paper books.
But prior to the preparation of paper book, my lord, I do not know what cans are there. My lord, there are
Cans are all disposed of.
all disposed.
Yes.
So, my lord, let the trial court records be called for. And my lord, and then
Trial court's records are already there.
Trial court records have come. There was no direction. Yes, record and order. Learned advocates for the parties are present. Let the trial court records be called for at the special messenger cost of the appellant to be deposited within 1 week. The paper books be prepared on arrival of the trial court records. Let this matter appear on okay 12/8/2026 under the heading hearing.
Grateful much.
12/8/2026 at timings ta bolo din at
let paper books be prepared. Let
okay 12/8/2026.
Grateful to much.
Grateful much. 92, my lord, I am 92, my lord, I am appearing on behalf of the appellant insurance company. I have deposited the entire awarded sum before my lord's court. This is my affidavit of service. And I have also served. It says delivered upon all respondents.
Okay. No, this
Let
is
my
can,
stay be absolute
No, no,
and the can be disposed of.
can
It's
what?
stay.
This is stay.
Stay.
Oh, you have deposited the entire award.
I have deposited. I'm giving the copy of the challan, my lord.
So so far the service of this application is concerned, it is complete.
Yes.
Yes, record and order. Learned advocate for the appellant is present. As the entire compensation amount is deposited in terms of
This is my original challan.
what is the earlier order for
Earlier order dated 28th of April 2026.
28th of April 2026. The ad interim order was in terms of earlier order dated 28/4/2026, the ad interim order of stay shall continue till disposal of this appeal. Stop. The appellant shall cause, so that direction is already there to cause service
Yes,
of
I have
notice.
served and affidavit of service also I have given. It says
Regard to application, but notice of appeal.
I shall serve. Notice of appeal I shall serve.
So earlier order, there was a direction to cause service of the notice. Probably, let me see.
I have done that on 18th of May, 2026.
18th of May. Service is affected.
That I do not know.
No, through the, see, through personally.
Personally, I have done, and Talabana and written up notice forms also I have put in for service of notice of appeal.
Yeah. Liberty to mention after 2 weeks.
Let the stay be absolute.
Yes, absolutely.
Fine.
It will continue till disposal of the appeal. Liberty to mention after 2 weeks, you take instruction. What is the position, service affected or not?
Or my lord will be kind enough to sort for a report from the department, because I have already put in the cost for service of notice to the concerned department.
Yeah. The service be affected in the meantime.
My lord, I'm grateful, my lord. Original challan
No, liberty to mention after 2 weeks, service be affected in the meantime upon the respondents.
I'm deeply obliged, madam.
Your Lordship, I'm appearing for the respondent number 4 and 5. There was a direction for affidavit in opposition. I've served the petitioner, but the state has refused to take the
You are for the applicant.
No, I'm for the respondent number 4 and 5.
Respondent number 4 and 5, it is your application.
Yes, Lordship. It's a recalling application. I'm the applicant.
So I granted opportunity to file.
Petition, Lordship.
So who is for the read petitioner?
Lord, I am appearing for the read petitioner, my lord.
Yes, you are the special officer. Yes, you are the read petitioner.
Yes, my lord.
So
led by-
regarding supplementary affidavit, you have received copy.
Yes, my lord.
Yes, Lordship.
So I granted them opportunity. So are you filing any opposition to that?
Filing, Lordship.
No, supplementary affidavit.
The supplementary has been hard out, Lordship.
I have granted liberty.
File opposition of the read, Lordship.
No. Probably. No. Question is, let me see. With regard to whether any facts were, let me see the earlier order. Dekhi.
Earlier order, your lordship kindly, sorry, my lord. Lordship kindly see. Your lordship, since they have actually put the question that suppression of material fact.
Yes.
That's
So
why your lordship has
respondent number 4 and 5 are directed to file a supplementary stating in particular as to whether any material facts were suppressed before this court in the read petition. So along with your recalling application, you are granted to opportunity to file a supplementary affidavit as to whether any material facts were suppressed or not. So that you have filed, that affidavit you have filed.
No, affidavit, that's why I'm not affidavit file
Affidavit filing, yes. Service করেছি আমি ওদেরকে। Service করেছি।
এটা কাদের? মানে petitioner.
In terms of the order dated 16/6/2000.
They are appearing for the
applicant respondent number 4 and 5.
Affidavit copy has been served, but I am for the petitioner.
Read petitioner.
Yes, Mr. Dotto, Dipanjan Dotto is appearing, Lord. He's not actually he's on legs. However,
State has refused to receive.
Yes, Lordship.
yes,
Anyway,
state I'm not for the state. Lord, Lordship, kindly give us 2 weeks time, Lord, to use the
record and order.
Use the
Learned advocate for the applicant respondent number 4 and 5, and learned advocate for the read petitioner, and the special officer is present in court. The supplementary affidavit, which is made ready in terms of order dated 16/6/2026, is filed in court by the respondent number 4 and 5. Be kept with the record. A copy be served upon the learned advocate for the read petitioner.
Already served. Already served.
Acha, which is already served. The read petitioner is granted time to file affidavit in opposition within 2 weeks. Opposition on or before 3/8/2026. Reply, if any.
But instead of 3rd August, your lordship kindly make it subject to correction on 5th August. On or
by
before
5/8/2026, reply if any by 10/8/2026.
No reply because they file opposition, we shall file reply.
No. To supplementary affidavit, rejoin that. Suppose it is her application to which you have filed opposition to the main application. It is supplementary affidavit to her application.
No, Lord. Is a
You
opposition.
see, recalling application is your application.
Yes.
Calling applicant file lordship.
Yes.
That after that lordship, your lordship directed to file supplementary.
Yes.
Supplementary had hard out lordship. They have filed their reply.
No. This is a separate issue. That supplementary affidavit was for a separate purpose. The supplementary affidavit 16/6/2026 is specifically you have to state whether while moving the writ petition they have suppressed any material fact. That you have stated.
No, that is not the supplementary. They have filed the opposition against the writ petition.
Very well. In that case, any material facts which is suppressed is dealt with.
My lord.
Very well. So you treat that as a affidavit in opposition to you treat that as a supplementary affidavit to the application for recalling.
My lord.
The supplementary affidavit. আচ্ছা পড়ুন তো অর্ডারটা কি লিখলেন? Stroke applicant. No, learned special officer.
দাঁড়া হয়নি এখন।
In court. No, supplementary affidavit. Affidavit is filed in terms of order dated 16/6/2026. You have stated that supplementary affidavit. Yes. Have you stated that?
No, stated affidavit in opposition.
I have stated opposition.
Although the nomenclature is used as affidavit in opposition,
but
it is treated as supplementary affidavit in terms of order dated 16/6/2026 to the recalling application being Can 1 of 2026. The writ petitioner is granted opportunity to file affidavit in opposition to the supplementary affidavit which is filed today on or before 5/8/2026. The reply, if any, be filed on or before 10/8/2026. Let this matter appear for necessary orders on 12 তারিখ হবে না? Okay, 13/8/2026 under the heading application.
Obliged to Lord. I'm deeply obliged to Lord. Formula accommodation.
Yes. Yes, you are for?
I'm for respondent.
I am for the appellant. There is a
respondent cross appellant. There's a cross appeal.
There is a cross.
Is it a claim case or just a general appeal?
Claim case. Claim case. My appeal is confined to the multiplier, which has been given as 2, and which I am claiming is 9. And in their cross, and they have filed a cross appeal also. My area of appeal is confined to that space only, that point only.
So it's an injury case.
Yes, it's a death case. Paper book and active paper book.
বাচ্চাটা ফাইল হয়েছে ওরা নেয়নি তাই দিয়ে দিয়েছে
Yes, what is your ground that the multiplier is not selected properly in accordance with the rules?
In that regard, I would be relying on the judgment of the Honorable Supreme Court of 2009.
Question is, here you see, what was the age of the victim?
Victim's age was 58, my lord. Page 43. In the award, it has been mentioned at the top.
You're for this SBSTC.
SBSTC.
It was not an insured vehicle.
It was not, my lord. We have a scheme, my lord, that under the Motor Vehicles Act, there's provision that we can, my lord, keep a reserve fund, my lord, for. And
Anyway, so it is no, some vehicles are insured. No, NBSTC vehicles are insured.
SBSTC, my lord, not.
Anyway, so let us see the judgment.
My lord, may I? The award, my lord. The award starts from page number page 30, and the relevant portion starts from page 40, wherein the multiplier has been considered.
Yes.
Page 40,
Yes.
third paragraph.
Yes.
It starts with regarding the age and income.
Yes.
And may I read it out, my lord? Regarding the age and income of the victim, Amal Kanti Ghosh, I find from the claim petition that the deceased was aged about 58 years at the time of his accidental death. From the postmortem report, I find that the age of the victim, Amal Kanti Ghosh, was about 58 years at the time of his accidental death. I find from the cross-examination of PW1 that the date of birth of the deceased was 8/9/1952, and therefore he was aged about 58 years, 8 months and 25 days on the date of his accidental death, that is on 2/6/2011. Accordingly, I hold that the multiplier of 2 would be applicable as he had more than 1 year of service left at the time of his death. My lord, this is the issue where we are contesting, my lord, and on the basis of the judgment of the Honorable Supreme Court held in Sarla Verma and others, wherein it has been held that where the age of the victim is 58 years, between 56 to 60, the multiplier should be 9. My lord, may I hand over the judgment?
Yes.
My lord, it would be from para 40 and para 40 to 43. The 40 is the table where in different cases the multiplier has been considered.
Okay, as per second schedule, how much it comes?
It should be 9.
Second schedule, it is 9.
My lord, kindly grant me a moment. No, second schedule. Second schedule.
No, as per Sharola Verma, you
Yes.
see. Yes, second schedule, it is 8.
8.
Second schedule, it is 8. So it is not disputed that it is between 56 to 60.
Yes.
As per second schedule, it is 8.
And in para
any future prospect taken into consideration? No, your ground of challenge is not future prospect.
No.
Only with
The
regard to multiplier. Yes.
My lord, the kindly come to para 42, where it has been held that the multiplier to be used should be as mentioned in column 4 of the table above.
Para 42.
Yes, my lord.
No, you see, this second schedule can also be followed. There is no bar because second schedule is also considered.
While holding that, my lord.
M9 for 56 to 60.
Yes, my lord.
Very well. Because you see, after all, just and reasonable compensation is to be awarded. So this is the one ground. Has
Yes,
any other ground you have taken?
No. This is the only ground which I am harping on. And in 2017, the Sarla Verma has been upheld in the means it has
Pronoy Shetty,
my lord.
Pronoy Shetty, what it says? 8 or
It's para 42, which I have just mentioned, my lord.
So that is to be followed.
Yes, my lord.
Did this victim get any service in SBSTC? Anything has come in cross-examination?
No.
Any service or any pension? I think there is no pension in SBSTC. Is she receiving any pension?
No, he was working in a Jila Parishad. He was.
Oh,
Sir, Jila Parishad is a pensionable job.
no. What is the evidence? Let us see.
Right.
Okay, that can be the ground of appeal of this insurance, this SBSTC. So anyway, your ground is that
Or
9.
multiplier.
Either 9 or 8, whatever it is,
Yes,
it has to be seen. Yes.
But in the cross appeal, my lord, the ground is that, my lord, the fact that the accident occurred due to involvement of the vehicle belonging to SBSTC, that has not been proved. The finding of the court is perverse, due the evidence. I'll indicate the reasons, you know, why I am submitting this. That is the ground of appeal. I have mentioned in the grounds also. The accident took place on 2nd of June 2011.
Yes, page.
Date of accident is not mentioned in the judgment, my lord.
No, what are your grounds
My grounds not kindly
of
take
doubting the case of the claimant?
Kindly takes up not the memo of cross appeal, my lord.
Yes.
It is not part of the paper book.
It's not part. Have you filed any supplementary paper book? देखिए मेमो ऑफ येटा क्रॉस ऑब्जेक्शन टा Yes. Yes. Which ground?
Lordship will not kindly take up.
Yes, belated FIR lodged after how many days?
FIR lodged, my lord, after 21 days. Now, the only witness, the lady, wife who has claimed she was not present at the time of the incident. She says 2nd June accident, 23rd June FIR.
Okay, so FIR lodged after 21 days.
21 days.
Yes.
Number one. Next, my lord.
Yes.
The lady says that I was not there.
So she is not the eyewitness.
No, she is not the eyewitness.
Okay. How many eyewitnesses are there?
One eyewitness.
That is PW2.
PW2. Who is not the nephew of that lady. She says, my nephew has seen. He was there. Now, at the time of lodging the FIR, there is no mention of the nephew.
Who lost the FIR? Some other third party?
No, the lady after 21 days, she lost the FIR.
Okay. There is no mention of the nephew.
No mention of the nephew.
Okay, let us see the evidence of this PW2.
Points are not this. First is the delay. Next, not the FIR doesn't mention the name of the nephew. Suddenly, at the time of the case, the nephew comes in. Next is the nephew, while deposing, does not say I am nephew. He says I am an acquaintance. There's total contradiction in the evidence.
Okay, let us see.
So I'm just indicating the points, my lord. There's a contradiction between the evidence of the lady that he is my nephew. Nephew says I am a mere acquaintance. Then, my lord, he says the number of the motor vehicle, motorcycle in which the deceased was riding, the number given by the lady and the nephew differ. They are giving two different numbers.
So let us see the.
My lord.
Okay, the lady has not seen the accident. Okay, so it has been seen by this nephew.
Kindly come to the evidence of the lady first, my lord. It is at page 9.
Yes.
Translated page is at page 11. I'm the only, or rather I can place not the Bengali version at page 9. May I place?
Yes.
কত ইংরেজি 2/6/11 তারিখ সকাল 9:30 নাগাদ kindly mention the time is also mentioned. GT রোড এর বটতলায় বাম বটতলায় অনাময় হাসপাতালের কাছে স্বামীর মোটর অ্যাক্সিডেন্ট হয়। ওই দিন ওই সময় আমার স্বামী ও তার নিজের মোটরসাইকেলে চেপে অফিস যাচ্ছিলেন। motorcycle number WB 42T 5919. Kindly mark this number because the nephew says something else. বর্ধমানের দিকে সেই সময় একটি সরকারি বাস যার নাম্বার WB 39A1345 ধর্মতলা থেকে দুর্গাপুরের দিকে খুব জোরে এবং বেপরোয়াভাবে চালিয়ে এসে স্বামীর মোটরসাইকেলের পিছনে ধাক্কা মারে এবং স্বামী ঘটনাস্থলেই মারা যায়। মৃত্যুর সময় বয়স ছিল 58 বছর। তিনি বর্ধমান জেলা পরিষদের অধীনে সিনিয়র গ্রেড অ্যাসিস্ট্যান্ট পদে চাকরি করতেন এবং মাসে 25,000 টাকা আয় করতেন। উক্ত বাসের চালকের দোষেই অ্যাক্সিডেন্ট হয়, ঘটনার জন্য চালক দায়ী। আমি মামলা প্রমাণ করার জন্য সরকারি কাগজপত্র আদালতে জমা দিয়েছি, দাবি সত্য। Then my lord.
Okay, now the question is regarding the offending vehicle. Is there any contradiction? So far, the motorcycle is concerned that was driven by the victim, but so far the offending vehicle.
Given by the petitioner.
No, the
motorcycle number was given by the petitioner. The
okay, motorcycle was driven by this victim. Okay, the wife, this person's husband. So now
eyewitness talks about some other motorcycle number.
Okay, motorcycle, but so far the offending vehicle.
Offending vehicle number is same because not my case is that he is a tutored witness because.
Okay, now the question is, did the SBSTC adduce any evidence?
The
What is the evidence?
Driver of the vehicle.
Yes, what did he say? Let us see.
I have never met with any accident. I have plied the bus. I left the office from Dunlop, went to Durgapur. No accident at all has taken place.
Let us see the evidence of OPW.
Before that, may I just complete the witness note cross-examination of the lady? Kindly come to page 13, my lord. Page 13, cross-examination.
Yes.
I did not witness in the middle.
Yes.
I did not witness the occurrence of accident personally. Manik Datto, my nephew, and his friend Sanjay Datto were present at the spot when the accident took place. So this is the evidence. Now, what the nephew says, if your lordship kindly comes to me at page 17, nephew's version, page 17, para 1, 2nd May 2011, 9:30 AM, I saw motor accident on GT Road at Bambortala. On that day and at the time, I was traveling towards Bardhaman for my personal work. At that time, a government bus bearing number WB 39A1345 overtook me and then very high speed and recklessly hit a motorcycle who was traveling ahead of me from behind. On going there, I saw my acquaintance HON'BLE Ghosh. But this is not a clearing thing because he is saying my acquaintance. Number one. Number two, the vehicle number here differs. Although the bus number is same, the vehicle number is different. Registration number of the motorcycle different from the number given by the lady.
Charge sheet submitted against the driver of this vehicle.
Was submitted.
Yes.
Now, my lord, one more thing, my lord. He says that I was traveling, my lord, towards Bardhaman. The bus came from behind, overtook me and dashed the motorcycle and went away.
Yes.
But he says, I have seen that in the front of the bus, there is a board written from Kolkata to Durgapur. Cross was put to him that how can you see where the hoarding was written, the route. He says in the front of the bus. And his witness is that I was traveling from the behind, it came and overtook me. In that case, it is not possible for him to see what was there in the front of the bus. If your lordship sees the cross, in the cross question was put to him. Page 19. Kindly similar in the middle. I studied up to so and so. I am attending the court on request of the petitioner. I had visiting terms with the deceased. So he is not a nephew. Completely a false statement has been made by the lady. I had visiting terms with the deceased. Civil suit is pending over the dwelling house of the deceased. I don't know with whom. I do not have any document to show that I was present at PO at the time. So he didn't go to the police station also. If he is the nephew, should have gone to the police station. Alleged offending vehicle was bounded to Durgapur from Dharmotala. I was also proceeding towards Bardhaman from Jotram's side. Name of the route of the bus was written on the front of the bus. Now he cannot see this. If it overtakes him from behind, as per his witness, he cannot see that the name of the route is written in the front of the bus. Then, my lord, the third witness is from Jila Parishad, PW3, to prove the income of the deceased.
Now the question is, so far the wife is concerned, So was there any evidence, any cross-examination, whether she has received any government service or pension? Have you challenged the quantum of compensation also?
No,
Or only the involvement?
Count is not the vehicle vehicle was not involved.
Okay. Let us see the cross-exam this OPW.
My lord. Cross of OPW. My lord.
26 onwards.
23 is the my lord, Bengali version. 26 is the translated version.
Yes.
I am the employee of this concern. I work that concern as a driver. I possess a vehicle driving license suitable for being engaged in that work. Have been working since 1990. Acquired sufficient skill and experience. Vehicle bearing registration number 39A1345 is a bus owned by the opposite party, used for passenger service. Bus was engaged for passenger service on 2nd June 2011 from Kolkata to Durgapur route. I was engaged as driver on that bus, set out from Kolkata to Durgapur carrying passengers, reached Durgapur through NH number 2 route. The bus belonged to Belghoria depot. On that day, my bus reached Durgapur on time. On the way, my bus did not meet with any accident, nor did it hit or cause the death of any person. The applicant in this petition alleged that I struck a pedestrian named Amal Kanti Ghosh and caused his death. This statement is completely incorrect. I came to know from my depot officer that on 2nd July 2011, a case being GR number 1072 was filed against me in the court of the Honorable CJM, that an FIR was lodged at Bardhaman police station on 23rd June 2011. Due to the criminal case filed against me, I applied for bail. Court granted the same. Later, after reading the FIR lodged at the police station, I came to know that it was alleged that I had hit the motorcyclist, namely Amal Kanti Ghosh, near Niramay Hospital by any side of NH2. No accident occurred involving my bus with any motorcyclist or pedestrian. Did not in any manner recklessly or high speed hit anyone. Allegations are incorrect. So this is not his evidence.
So this victim died on the spot or taken to hospital?
Not,
died on the
spot. Died on the spot. OPW, my lord.
Okay, his cross-examination.
Cross-examine, my lord. Now, cross-examination doesn't, my lord, show or not his case not is not displaced by cross-examination. If your lordship sees not page 28, the version that he has given in the chief, my lord, is maintained in cross. He was given a suggestion whether you have lodged any complaint or not. He has said, no, I have not lodged any complaint for the false case.
So the timings of the accident?
Time, it says 9:30.
So 11 a.m.
9:30.
Okay. Okay. He reached Durgapur. From 11 a.m. to 11:30 a.m.
There are so many buses not from Belghoria depot to Durgapur Milot in that same route. Number one. Number two, whether this bus at all was involved, that has to be proved.
From Belgachia? No, Belghoria.
Belghoria.
So now the question is, you see, the timings of the accident? No, here it is stated, okay, the starting point of the journey is 7:30 a.m.
Yes. On the basis of that, not presumption cannot be drawn that this particular bus has caused the accident. Only on the basis of which the court has done, that it has started, it has gone to that destination, so it must have done it. But the probable time is similar. That is the presumption drawn by the court.
So, but this vehicle has passed. Now it is not a thing that this vehicle number did not pass. From evening it passed.
No, that is not the case.
So it's not some.
Now this information, why I say, my lord, the late lodging of the FIR is not vital in this case, my lord. This 21-22 days was taken to lodge the, my lord, FIR. In the FIR, kindly comes to the FIR. FIR is not at page 1 of the, my lord, part 2.
1 of part 2.
Part 2.
Page 5.
Page.
English version.
Kindly come to page 3, my lord. It's a handwritten complaint. May I read? Amar binito nivedon ei.
Page 3.
Page 3, my lord, of part 2. Amar binito nivedon ei.
No, this is part 1.
It contains the second part 2 is contained in the same compilation.
Same volume.
Same, only one volume, my lord. Back part is part 2.
Yes. This is a translation also.
Yes, page 5, my lord. Page 3, my lord, if your lordship can.
Page 5.
But I would place, my lord, page 3 because that is the original version of the FIR.
Yes.
আমার বিনীত নিবেদন এই যে আমি শ্রীমতী গীতা ঘোষ, স্বামী অমলকান্তি ঘোষ, সাকিম আমার স্বামী অমলকান্তি ঘোষ বর্ধমান জেলা পরিষদের একজন কর্মচারী ছিলেন। গত ইংরেজি 2/6/11 তারিখে সকাল 9:30 নাগাদ অফিস যাওয়ার জন্য নিজের মোটরসাইকেল করে, যার নম্বর WB42T0919, জিটি রোডে যাওয়ার পথে তলার কাছে অনাময় হাসপাতালের কাছে পৌঁছলে সেই সময় একটি সরকারি বাস, যার নম্বর WB39A1345, ধর্মতলা থেকে দুর্গাপুর যাওয়ার পথে অত্যন্ত বেপরোয়াভাবে দ্রুত গতিতে এসে পিছন দিক থেকে ধাক্কা মারে, যার ফলে আমার স্বামী অমলকান্তি ঘোষের এই বাসের ধাক্কায় ঘটনাস্থলেই মৃত্যু হয়। উল্লেখ্য যে উপরোক্ত দুর্ঘটনাটি বিভিন্ন দূরদর্শন চ্যানেল এবং ইটিভি, জিটিভি, জিএন, 24 ঘন্টা কলকাতা টিভিতেও আমার প্রকাশ পায় ও বিভিন্ন খবরের কাগজেও প্রকাশ পায়। উপরোক্ত অ্যাক্সিডেন্টটি WB39A1345 সরকারি বাসের ড্রাইভারের ইচ্ছাকৃত বেপরোয়াভাবে অত্যন্ত দ্রুতগতিতে চালানোর ফলে আমার স্বামীর মৃত্যু হয়। আমার স্বামীর আকস্মিক মৃত্যু হওয়ার ফলে মানসিকভাবে আমি বিপর্যস্ত হয়ে পড়ি, অসুস্থ হয়ে পড়ি এবং তার পারলৌকিক ক্রিয়াদির জন্য অভিযোগ জানাতে দেরি হলো। প্রকাশ থাকে যে উপরোক্ত ঘটনার পরিপ্রেক্ষিতে থানায় একটি ইউভি কেস শুরু হয়েছে, যার নম্বর 595/11. Now kindly will not marks here that there is no mention that her nephew with his friend was present at the time of the accident. If not, he very well. She took 21 days to recover and go and lodge the FIR. Now the person, her family member who is present at the time of the incident, there is no mention of that. That is why I say he has been set up subsequently. She must have mentioned in the FIR that my nephew was present there. The nephew says that I am a mere acquaintance, I go to their house. Your Lordship has seen, he says, Jawa asha ache. So the person who has been set up, his name is not there in the FIR. Subsequently, my lord, they find somebody, an acquaintance, she says that he is my nephew, and his name is included in the charge sheet. This is what has happened.
So what is the evidence, let us see, of this SBSTC?
SBSTC. OPW 1, my lord, page
SBSTC, written statement.
Written statement. Page 5, my lord.
Yes.
Paragraph 10 is important, my lord. After dealing with the allegations, my lord, para 10 may I read? This opposite party submits that from the official record and statement of the driver and conductor, bus number 39A1345, no such occurrence took place, nor the bus ever knocked down any person, far to speak the victim. This contention finds support from the fact and attending circumstances. If there had really been accident on 2nd June 2011 caused by the driver of the vehicle of this opposite party, the FIR in PS would not have been registered on 23rd June 2011. More particularly, the alleged place of accident is close to Burdwan town. Driver of the vehicle, as alleged of this opposite party, are experienced and has got well-known reputation. On inquiry and from the statement of the driver, the opposite party strongly believe that that with a view to claim compensation, the FIR has been lodged after making allegations against the driver of the opposite party. These vital points might have not been considered at all by the judgment team. The vital point that whether she says nephew, but the person says I only acquaintance, go to their house. First, incorrect statement made by the wife. Second point, that in the FIR she didn't mention about the so-called nephew to be present. If the person comes later. Thirdly, the version of the nephew is also contradictory, because he says that the bus came and overtook me from behind, but he can see what is written in front of the bus. Now, how is that physically possible, my lord? If he is on a motorcycle, the bus comes recklessly in a high speed and passes him. Can he see him? Is it possible for a person to see what is written in the front of the bus? Then he doesn't go to the police station. If he is not so close.
So is it stated the bus fled away in the FIR?
Yes.
Or the bus was there stranded
No. Fled away.
in the FIR or in the
In his PW2 chief, I'll place, my lord. Just a second.
no, what he said, the after the accident, it
Page
fled away.
17.
Anyway, there is no such statement that the bus fled away. So there was no scope to record the number.
High street.
Just no. এটা কি বলিস? না, সেটা তো বলেছি ভাইপো যে সেটা তো না ভাইপোরটা না, পুরোটা সবারই দেখতে হবে তো।
Anyway, there is no such
statement.
pleadings that after the accident, the bus fled away. So there was no scope to record the number.
সেজন্য বেপরোয়াভাবে অত্যন্ত দ্রুত গতিতে চালানোর ফলে আমার স্বামীর মৃত্যু হয়। Then it was not even stated that after dashing, he has to specifically state that after dashing the motorcycle, the bus stayed and waited there.
Very well. So, no. Question is, if the bus does not flee away, there is always a scope.
No, he says that it overtook me from the back and.
Very well. You see, moment accident takes place, it's a government vehicle, it will not run away. So there is a scope to record the number.
But there is no evidence on record also, including the evidence of the driver says that nothing has happened.
Very well.
No stoppage.
Driver will, he's an accused. He will always deny his liability.
So noting the number, Millard, is maybe possible. That from the behind also you can note the number.
Yes, number is noted.
So far as not the route written in front of the bus, Millard, that is not.
So number is vital. Okay, the number is vital.
Number is
so
noted.
the number tallies with the route.
So number, Millard, the person comes as a witness when already, Millard, the petition has been filed. So he knows the bus number, but the other things which come out of cross-examination and his evidence, these discrepancies are to be, Millard, considered.
Number and the factual, what he saw, okay?
Yes.
Unless there is an evidence the bus flees away, there is every possibility to see the number.
Maybe he
or not number, even from the bus itself, it is not a difficult.
From the route of the bus.
So it's not a small bus.
I harp more on the credibility of the person himself.
Yes, so that front side or back side, to know the route, it is not a difficult task. That is not a fatal issue.
But the other aspects, Millard, has not been considered by the court.
And you know, in claim case, it is not necessary to prove a case beyond reasonable doubt. Anyway, with regard to the involvement, you have challenged. Have you challenged with regard to quantum?
Quantum, Millard, there are no grounds, Millard.
The interest awarded 9%. Okay. No, this is.
This is our memo.
Oh.
Last round.
Interest awarded was how much?
9% has been granted.
9% is granted. So.
Yes.
And so far as income is concerned, Lord, the gross income has been taken without statutory deductions.
Statutory deduction, how much? Okay, just a minute.
If not, he is getting salary of 27,000 per month.
20,000.
No, court has taken. Court has taken, kindly come paragraph, page 14, third paragraph. Full salary has been taken. 27,070 per month.
So salary slip was exhibited?
Yes. Personnel from the
No,
Parishad came at
salary, no, how much? That is
27,000
720.
per month.
So from which the income tax and the
12
profession tax should be deducted?
deducted. That is not done.
So that has to be done. No, you have not challenged the quantum.
No, the certificate is at page 12, part 2, my lord.
No, page 12 by part 2, that is profession tax and income tax, that is 650. Okay. So this, no, here you see,
There is a deduction made on that particular month, but not.
no,
calculation
total
has
is
to be made
27,720.
So total
Out
income
out of
minus-
which this 650 ought to have been deducted. The learned trial court proceeded on what income?
My lord, kindly see income tax 500 might have been deducted, but what is the total income that can be calculated? My lord, I
500 and as well as this profession tax.
If not 27,720 is the my lord, total gross salary, then what shall be the total income and what shall be the income tax? I can not calculate that and
No, it is already, there is a deduction.
So that is on that particular month he has deducted from his
Very
salary.
well.
Maybe.
So
Deduction might not be the same as the-
27,720 is the amount, that is the gross total amount. Okay, this is only 1 day, 1 month salary slip.
1 month salary slip.
Salary slip matter certificate.
The salary
Page
certificate.
43, volume 1 is the observation of the honorable of the learned tribunal.
তো ক্যালকুলেট করুন না কত হচ্ছে 27,700
The calculation has been
বারো
observed.
দিয়ে গুণ কর। I'll come up with the figure of the income tax. What should be the income tax?
Yes,
I'll come up with that.
GPF, which was used to be.
তো কি স্যার তো তখন দেখতে হবে না তো ওই সময় আমাদের 1.5 লাখ টাকা ছিল স্ট্যান্ডার্ড ডিডাকশন বলে দেখতে হবে ক্যালকুলেট করতে হবে হবে কি সামান্য ট্যাক্স হবে 8-10 হাজার টাকা ট্যাক্স হবে হয়তো ওটা যেতেই পেয়ে যাবে ওই সময় কোন মাসে থাকে এটা
27,070.
70 has been taken.
Yes, so 27,070.
দেখতে হবে স্ল্যাবটা কি ছিল এটার হিসাবে ধরলে হবে না তখন 10% 20% হবে
So the multiplier is 2.
Yes.
Yes, your ground of contention is only with the regard to the involvement of the vehicle. That is your main ground.
Accident was not proved by cogent evidence.
Anyway, I shall consider. Yes, record an order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. This matter. Yes.
Only one point. The only one judgment regarding the delay in filing an FIR will not be fatal to the case. That
Anyway, you may file that.
Yes. And one would charge sheet also to be considered.
Without placing the at least not hand over a copy so that I
You
can
hand over to a learned friend. You want to submit with that, or you need not submit that. Okay.
My lord.
Very well.
Then kindly consider the charge sheet.
Very
Page
well.
10.
Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 1/8/2026.
But since he has referred to the charge sheet, none of the other charge sheet named witnesses came to depose before the court. Only this particular person.
In the charge sheet, it's clearly mentioned that that bus was particularly involved having that registration number. Great point. No, that's okay.
And item 4 and item 6, both are under 163A proceedings. So your lordships kindly take up.
Item number 2, I am appearing for the judgment number 4.
Okay, item 4, you are for?
I am for the appellant. My learned friend is insurance company.
Item 4 and 6 arises out of the self-same accident.
No.
Or different case. But you are representing the insurance company in both the cases.
163A proceedings, that's why, Mila.
First lordship, four should be disposed of thereafter.
Copy is not.
What copy?
Copy and
No, I am hearing out the appeal. Acha, the paper books are ready.
Lordship, paper book already submitted. This is 163A application.
No, you are representing whom?
number 4, owner.
Respondent number 4.
কি রেস্টুরেন্ট নাম্বার 4 আপনি
No, in which case you are representing the vehicle owner?
6.
In respondent case number 6. Okay, case number 6, it will be taken up on some other day. Let us take up response this case number 4.
My lord, 6 is also identical case, my lord.
No.
The argument also both sides have been.
Here was a partially completed written.
But the learned advocate for the vehicle owner did not get opportunity. So are you involving the?
No, I'm not.
No, are you disputing the involvement of any vehicle?
No.
Only quantum is 163 principle of Pranay Shakti was applied and 7 lakhs and 50,000
163A
was awarded. So that's why you have.
Anyway, let us see item 4. Thereafter, I shall come.
Item 4 lordship, they are claimant lordships, wife and father, mother. And lordship 163 application, judgment passed lordships 7th May 2022, and learned tribunal judge lordship already given lordship 4,12,500, and lordship as per lordship amendment MV Act lordship another 87,500 will be entitled by the claimants. This much lordship. Paper book lordship page 30 judgment.
Page 33 million award was 4,12,500.
4,12,500.
Ultimate person. Now he is claiming a
Another
retrospective effect. Not only
87,500 along with
The judgment is passed on May 2022.
22 lordships.
Only thing that judgment is not faulty on the ground. Even 2025 Supreme Court 25 applied the same principle. Date of accident is that date must be considered, and 163 schedule should be followed.
Let
So
us see
far
that.
And so far the interest part in this particular case, more than 2 years has been the delay in filing the appeal.
Okay, how much interest is awarded?
6%.
6%.
Yes, lordship.
Delay of 2 years, more than 2 years. Supreme Court say that delayed period.
Delay of 2 years of what regarding?
Filing appeal.
Oh, this appeal.
Yes. It was content. So.
But interest is already awarded 6%.
Yes, lordship.
But that delayed period, she is not entitled to any.
Now, question is, have you filed your cross objection with regard to that?
No, I need not.
Because you see, her ground of challenge is only with regard to that uniform amount.
Uniform 5 lakhs.
5 lakh, but not with regard to any interest. But so far you are concerned, you did not file any cross objection.
No, I did not file.
So only that point is to be taken up.
Yes.
No, so along with interest, 87.
No, interest is already awarded to you.
Lordship, already awarded, lordship 40, 4 lakhs 12,200. But this is also from claim application to it.
That is how much? From the date of filing of the case? Yes, from the date of filing of this case. That is from 3/10/2015.
Lordships.
Yes.
Your Lordships, every court is your Lordships also granted. My land.
No, question is the 6% interest is granted from the date of filing of the case.
Yes, Lordships. That is earlier Lordships tribunal awarded amount. But your Lordship is enhancing, that should be considered.
Anyway, let me see the judgment.
Supreme Court says a delayed period. She cannot.
No, regarding that 5 lakh.
Yes, Usha Devi, even to 2025. Otherwise, there is a item number 6. I have filed a written notes of argument. I have challenged that decision that.
This case, you have filed written notes.
No, item number 6.
কেন বলছেন আপনি? এটা তো আলাদা।
Here, Ram Khiladi Singh was relied upon. So Ram Khiladi Singh was passed in 220. That decision was not considered subsequently in Urmila. And even 2025 Supreme Court, paragraph 14 and 15, kindly see this, of the Usha Devi case. It is passed in 2025 and applied the principle of schedule. Since the accident was happened at that relevant time, that was the law. Now, your lordship, I leave it to your lordship.
The accident happened in 2015. If it is, let's say it's filed by learned court, by learned advocate, 166, then it should be increased. But learned advocate
Who
don't do
prevented
that.
to file a
So
166?
that is why insurance company also lordship enrich and lordship they are rural poor people. They have no knowledge about any legal complexity. What is doing by the advocate, they are accepted. But that should be considered.
So apart from this decision, anything else you want to submit?
No.
And this is with regard to interest.
Yes, so interest 4.1. Yes, file the present appeal after even more than 2 years, after 2
No,
years.
question
So,
is her grievance is not with regard to appeal.
no.
With regard to interest.
Now if your lordship is kind enough to grant the additional amount, 5 lakhs minus 7, then your lordship also grant the 6% interest from the date of filing to the
Today.
That against that submission, I'm filing this application decision where Supreme Court held 4.1. If he has filed the appeal, present appeal after long delay, then in that event he cannot claim for the delay. Interest for the delayed part. Supreme Court categorically said 4.1.
Long.
How
much?
দু বছর
না, এখানে কি লিখেছে? There is no at all specific long and delay.
Already
lordship's discrimination power.
No.
Then
That
it is our laches, advocate laches. Then how
Then
can
you are not
it is
entitled to-
social obligations of the advocate?
no interest. Supreme Court categorically held.
Social obligations of the advocates.
That's
lordship.
Yes, record and order. Learned advocates for the parties are present. Are learned advocates for the parties. The grievance of the appellant's claimants in the instant appeal is that the learned trial judge, instead of awarding compensation of rupees 5 lakh as provided under section 164 of the Motor Vehicles Act 1988, has awarded compensation of rupees 4,12,500. Stop. Learned advocates for the appellant submits that under the latest amendment made in the Motor Vehicles Act 1988, the appellants are entitled to compensation of rupees 5 lakh. Stop. Learned advocates for the respondent number 2 insurance company, respondent number 1 insurance company submits that the appellant claimants are not entitled to compensation of rupees 5 lakh in view of the decision of the Honorable Supreme Court in the case of New India Assurance Company Limited versus Usha Devi and others, reported in 2025 within bracket 3, TAC 360 within bracket SC. Upon considering the provisions of the section 164 of the Motor Vehicles Act 1988 and considering the date of judgment, which was on 7th May 2022 passed by the learned trial judge, and considering the relevant judicial decisions with regard to the amendment of the Motor Vehicles Act in section 164, this court is of the view that as the decision relied upon by the learned advocates for the insurance company respondent number 1 in the case of New India Assurance Company Limited versus Usha Devi and others within bracket SUPRA, Supra, does not deal with the entitlement of the claimants under section 164 of the Motor Vehicles Act 1988. This judgment cannot apply in the instant case. Stop. As motor vehicles claim legislation is a beneficial legislation by virtue of the amendment in which the compensation amount in the case of no-fault liability is enhanced and made uniform at rupees 5 lakh, it would be just and proper to award rupees 5 lakh to the appellant's claimants. In the facts and circumstances, this appeal FMA it is 674 MB 674 of 2024 stands disposed. The judgment and award passed by learned Additional District Judge, Third Court, Barhampur, Murshidabad, in MV case number 765 of 2015 stands modified to the extent that the appellant's claimants will be entitled to compensation of rupees 5 lakh from the respondent number 1, New India Assurance Company Limited. Stop. However, with regard to grant of interest with regard to the delay in preferring the appeal, the decision relied upon by the learned advocate for the respondent number 1 insurance company in the case of executive engineer Nimanna Dudna project Telu district Prabhani versus State of Maharashtra, reported in AIR 2020 Supreme Court 717, cannot apply in this case. Stop. In the said case, the matter was with regard to the land acquisition and did not deal with the motor accident claim cases. Stop. Motor accident claim cases being beneficial legislation, the award of interest should not be refused unless there are special reasons. Thus, the appellant's claimants are entitled to compensation of rupees 5 lakh along with interest at the rate of 6% per annum from the date of filing claim case till today. Stop. The respondent number 1 insurance company shall deposit rupees 5 lakh along with interest.
Already awarded amount.
Yes. Along with interest at the rate of 6% per annum within 8 weeks from the date of communication of this order. Stop. In the event the compensation awarded by the learned trial court is already deposited, the balance amount be deposited. The appellant's claimant will be entitled to withdraw the compensation upon compliance of necessary formalities. Okay. Yes, 6. Yes, 6, as the learned advocate for the vehicle owner wants to take some time, you just come ready. You serve him a copy of the paper book?
Paper
book. My lord, your paper book is not needed, my lord, in this case, because we have already filed.
I don't know whether.
Only, my lord.
No, but the learned advocate for vehicle owner is handicapped. He has no documents with him.
Then we shall serve, my lord. He can serve, my lord, one copy of memo of appeal. Only. Also, I have only one equipment.
So far the 6, we have not. 163
না এটা তো হয়ে গেল 4 6 item 6 item 6 6 এ উনি অ্যাপিয়ার করছেন 5 just wait for some time.
So far the item 6 is appeal of the insurance company on the ground the amount was granted more than 7 lakhs and odds. There's no point involved for pay and recovery. There is a violation transfer. So I will supply the copy of a memo to the
only the quantum is under challenge.
That's why, and we have already filed a written notes of argument considering every decision.
Because there is no direction for pay and recovery.
No, we have not asked for.
Anyway, once you have made him a party and served him, he has a.
Yes, I will give a supply a copy of a memo. The first time he is appearing, it was hard to take up for many.
I'm keeping it on any day at 4 p.m.
Under the ring fixed matter.
Yes. Any day at 4 p.m.
On 4th, there is
On 4th.
Record and order. Learned advocates for the parties are present. On the prayer of learned advocate for respondent number, you are for 4. The matter stands adjourned to 3/8 to 3/8 এ 4টের সময়
এটা 5 মিনিট শুধু তো
only 5
আচ্ছা 3 তারিখ তাহলে দেখুন কবে আছে।
4 তারিখ আমার আরেকটা আছে তো দেখুন না কেন। কিন্তু কপি তো হয় এমনি তো সব হয়ে গেছে তো নামটা দিন।
5/8/2026 at 4 p.m.
কোথায় বসেন যেখানে
Yes, call item 5.
But I am appearing in this matter on behalf of the respondents claimants.
I am appearing on behalf of the appellant insurance company.
So there is no cross objection.
Yes, the cross, it's not appearing in the list. Let it be treated as on day's list. It's part of the paper book.
My lord, this is injury case, my lord.
I mean,
During pendency of this appeal before this honorable court, my lord, the injured respondent claimant, my lord, expired. But I have filed one substitution application that has already been allowed by your lordships, and my lord, the legal heirs already been implemented in this case. The wife and son and daughter, they are all major.
The victim, my lord, the accident, it took place in the year 2017. 28th of November 2017, 141-year-old man, he suffered injuries, my lord. He was allegedly dashed by a motorcycle, and his right leg below knee was amputated. The learned trial judge, my lord, on 31st of July 2024, awarded a total compensation of rupees 20 lakh and odd on a number of heads, including the pecuniary as well as the non-pecuniary damages. Now, I have come up in appeal, my lord, on the ground of, on a number of grounds. First being delayed lodging of FIR. I dispute the involvement of the offending motorcycle.
Vehicle number was mentioned in FIR.
Yes, it was mentioned. It was lodged after 36 days by the victim. The first information report is at page page 56 is the relevant of the paper book. Page 56 is the written complaint, my lord, filed by the victim himself. Page 56, my lord has found. Yes, the last but one line. In Bengali, it's written, Goto Ingreji 28/11/2017 তারিখ থেকে 3/12/2017 তারিখ পর্যন্ত চিকিৎসা হই, কিন্তু চিকিৎসার কোনো উন্নতি না হওয়ায় বাড়ির লোকেরা
Page 26.
56.
56.
Last line, page 56,
Yes.
last line. Page 56, last line, my lord, last but one line, the relevant portion. Before that, 1, 2, 3, 4, 5. At the 6th line, my lord, the number of the offending vehicle he has mentioned. The last but one line, my lord, গত ইংরেজি 28/11/2017 তারিখ থেকে 3/12/2017 তারিখ পর্যন্ত চিকিৎসা হই, কিন্তু চিকিৎসার কোনো উন্নতি না হওয়ায় বাড়ির লোকেরা কটকের কৃষ্ণা হসপিটালে ভর্তি করান। গত ইংরেজি 4/12/2017 তারিখ থেকে 18/12/2017 তারিখ পর্যন্ত চিকিৎসা হই, কিন্তু thereafter he says that nothing happened, so his leg had to be amputated. Now, FIR, my lord, it was lodged on 4th of January 2018. That is much after this 18/12/2017, till when he was admitted in Krishna Hospital.
After discharge, how many days delay?
18th to 8th of January. ওখানে 8 এখানে
18 December, he was discharged from Krishna Hospital, Cuttack.
and the FIR was lodged
4th January.
Around 20 days
So it was lodged where? In that local police station?
in the local police station.
By the victim
আমি একটু
himself.
বলে নি Look, local police station.
And in Odisha?
No, this was lodged at this Midnapur.
No, incident took place?
It's-
Midnapur. Right.
Incident took place at
No,
Midnapur.
Kotak Hospital it is.
He was transferred to Calcutta hospital because his condition was not improving.
Kotak Hospital he was discharged.
He was discharged. He came back, and thereafter
Midnapur.
at Midnapur he lodged the.
18th of December and 2nd of
He was discharged on 18th of December, and he lodged the FIR on 8th of January, 2018.
Okay, after 20 days from date.
It's almost 20 days. Near about 22 days. So the total delay was of from the date of accident. It was 36 days. That is why I have disputed the involvement of the.
Thing in the discharge certificate, was there anything mentioned? Rest for so and so days or?
I'll just check.
Anyway,
It's at page 66.
Come after recess.
My lord.
If the other matters
Lordship.
are not taken up, it is that if it is adjourned, there are other fixed matters.
Lordship.
If time permits, this can be taken up.
My lord.
Kindly continue this matter, my lord, after 2.
No, there in 2 there are fixed matters 2 and 3. If the matter is adjourned, then I can take it up. Or if time permits, I can take it up.
ও judgment আছে sorry. I am for the appellant, my lord.
Yes, hence this appeal FMA 160 of 2012 stands dismissed. Judgment and award dated 12/7/2011 passed by Learned Additional District Judge 6th Court Alipur in MSCC number 165 of 2006 with regard to the principal compensation awarded is affirmed. However, with regard to interest, this court is of the view that interest of 6% per annum is just and reasonable, and the same is reduced to 6%. The appellant insurance company shall deposit before Registrar General High Court, Calcutta, rupees 98,403, along with interest at the rate of 6% per annum from date of filing claim case till today. Such deposit shall be made within 8 weeks from the date of communication of this order. In the event compensation awarded by Learned Trial Court is already deposited, no further deposit be made. The respondent claimant will be entitled to withdraw the compensation amount along with interest upon compliance of necessary formalities. Balance amount, if any, along with accrued interest, be returned to the appellant insurance company.
Yes, lordship, I am appearing with the appellant.
I'm praying for adjournment.
You are?
I appear for the respondent, defendant.
Was this matter heard earlier?
No, lordship is fixed for hearing. Injunction stay order was extended, lordship. Last directed to file paperwork. Paperwork already filed, and LCR also received.
So trial court records have come.
Yes, yes.
So are you ready, both of you?
I am not ready. I was suffering from fever, my lord. Last week, my lord, I could not make myself ready.
So he can start. You submit on the next day.
Kindly make it not this week, my lord. From next
You see, if we don't start matters, we will not be able to complete.
Lord, only 1 week.
At least, however long a matter may be, a journey may be very long, but unless you begin the journey, there is no scope of reaching your goal. Next week, 1st August?
No, no, no.
That means you don't have any urgency.
No, 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 I'm not.
So
personal.
if you have urgency, then why not?
No, no, urgency is there. That day I cannot.
So you don't want. তার আগে হচ্ছে না কিছু মানে তিনটের সময় যে কোনো দিন Yes, learned advocates for the parties are present on the prayer of learned advocate for the respondent. The matter stands adjourned till 13/8/2026 at 2 p.m. So please come ready on that day.
Interim order lordship.
The interim order granted earlier stands extended for a period of 6 weeks or till further orders, whichever is earlier. ও এরপরে তো 3 PM নেই তো কিছু হ্যাঁ তাহলে এখন ওইটা যেটা শোনা হচ্ছিল ওটা কল করে দিন
5
কি না যেটা তার পাস ওভার ম্যাটার কোনটা বলছেন ওটা বেশিক্ষণ লাগবে না
5 So as I was submitting, my lord, I have preferred the appeal on a number of grounds. One being delayed lodging of FIR.
Yes.
Accident took place, my lord, on 28th of November 2017. Written complaint was lodged on 8th of January 2018 by the victim himself.
Yes.
In between, my lord, he was initially being treated at কোথায় ওকে প্রথমে করছিল দেখছিল না আচ্ছা initially he was being treated at one hospital, but since his condition it was not improving, my lord, so he was shifted to Krishna hospital. Therein he remained admitted till, my lord,
Cuttack Hospital.
my lord,
Cuttack Hospital.
Cuttack, Krishna hospital at Cuttack. So at Krishna hospital, my lord, he remained admitted till 18th of December 2017. And thereafter, my lord, he filed the written complaint on 8th of January 2018. That, my lord, will find from page 56, which is the written complaint. And the motorcycle, my lord. This motorcycle was also seized from the owner. The owner produced it himself before the concerned police station. That, my lord, will find from page number 64.
Vehicle number was mentioned.
Vehicle number was mentioned.
Owner himself produced the motorcycle.
Yes, that is at page 64, the seizure list, exhibit 5. And the discharge, before rising, my lord, had asked me the question whether this discharge certificate, my lord, at page 66, whether it mentions anything about this resting period.
Page 66.
Page 66. It does not mention, my lord. There is nothing mentioned regarding the resting period, whether he should rest for a certain.
Page 66.
Page 66, my lord. Of course,
How many days he was in hospital?
He was in hospital from 28th of November till 18th of December. So 18, 19, 20, almost 20 days.
20 days.
Almost 20 days. And it's a case of amputation. His right leg was below knee was amputated, my lord. This discharge certificate.
Yes.
It says it of course it mentions about road traffic accident on 28th of November. I'm also not disputing the accident. My only contention is regarding the involvement of the vehicle. I dispute the involvement of the concerned motorcycle in the accident.
Yes.
This is my first ground, that is delayed lodging of FIR.
Yes.
The second ground, my lord, I have taken is regarding income. The victim, my lord, he was working as a supervisor at one Makali enterprise, and he was earning about rupees 10,000 per month. PW4, my lord, who is the employer of the victim, that is at page 22 of the paper book. He came and deposed before the trial judge, my lord. Page
PW3.
PW4.
That is the employer.
That is the employer.
That is page
22. Page 22. Why I dispute the income, my lord? Because PW3 in his cross examination, last line, my lord.
This is the employer.
Employer.
PW4.
PW4. I'm sorry, PW3 I said. It's PW4. At page 22, why I dispute the income? That is because PW4, my lord, while deposing, the last line in his cross examination, he says that there is no document to show that he, that is the victim, is receiving salary of 10,000 in every month. PW4, my lord, thereafter, the next page, page 23, my lord will kindly come to. I maintained income tax file of my business. He had, I pause here for a moment, he had income tax file. He recently have started the provision of PF for my employees, but he did not maintain any register to show the number of employees he had, how much they were being paid. And
what is the nature of business?
Nature of business. He was a contractor.
Government contractor?
No, there is no evidence that he was a government contractor.
And he is a contractor.
He was a contractor.
Oh, right, contractor.
Contractor. He had exhibited his trade license, a number of trade licenses, but he did not maintain a register or even the pay slips. Wherein the
Which page is this?
My
is
lord,
this certificate?
that is at page 103. This sort of certificate, my lord, anybody can prepare. Page 103. This is exhibit 15.
No, but the maker of the document has come.
Yes, yes, yes.
Not that.
My lord, my lord, my lord. 103.
Government contractor.
Oh, yes, yes. He is a government contractor. He is a government. Be that as it may, my lord, why I dispute this, as I was saying, that he maintained, he used to file his income tax returns. Then he had also started that provision of provident fund for his employees. Then he had trade license, but he failed to maintain one register, or even he failed to produce that those receipts, my lord, wherein his employees, they would sign and receive the salary. So that is why I have disputed this 10,000 rupees income per month. The other ground of appeal, my lord, it's on the ground of non-pecuniary. The learned trial judge, my lord will kindly come to the award at page 40.
Yes, page 40.
The future prospect, I must be candid, it was not granted. Victim was aged about 41 years. So his future prospect, he was entitled
20%.
to 40%. Oh, he was aged about 40, 25% he was entitled to. Yes, yes, I'm sorry. He was entitled
Page
to.
40 is the
Page 40 is the assessment.
non-pecuniary damage.
Non-pecuniary damages. Herein, my lord, your lordship will see the calculation portion at the end. Loss of earning, page 40.
Page 40.
The computation of compensation amount.
Yes, yes.
Therein, my lord, multiply thereafter loss of earning 10,80,000.
That is ascertained on the percentage of disability.
Yes, 10,80,000.
Into multiplier of 18.
Yes, this will change because victim was aged 41 years. That, my lord, while herein the learned trial judge, my lord, took the income to be 34 years.
No, age.
Yes, I'm sorry, the age to be 34 years.
Age was 41.
Age was 41 years. So that multiplier will change.
How much it comes? 41?
It should be 14. Herein 18 was applied.
So multiplier should be 14.
It should be 14. My lord will come to the Aadhaar card that has been exhibited. That is at page 102. His that is exhibit 13, Aadhaar card, my lord. Year of birth, it's 1976, and accident took place in the year 2011.
That means, you see, 1976.
Lordship.
About 35 years.
As per the, I'm sorry, as per the Aadhaar card, it was taken to be 35 years, but in all the hospital documents, it is 41 years. My lord will kindly come to page number. My lord will kindly come to page number 107. It's from Vivekananda Hospital. It's the bill. My lord will see male aged 42 years.
Yes.
42 years at the top age.
Yes, doctor's certificate, first admission certificate. What does it say? Let us see. That has to be relied upon.
My lord.
42 years, Vivekananda Hospital.
Yes.
In the medical certificate.
Exhibit 18, my page 105.
Yes, 105, it is 42
yes,
years.
42 years.
And
107, my lord, it's 42 years.
107. Yes, 42 years.
42
This
years.
is the hospital where he was first admitted.
He was admitted at, my lord, Midnapur Medical College and Hospital, 117, 42 years. 117.
All discharge certificate, 42 years.
42 years.
So if it is 41 years, it comes to 40.
Between 41 to 45, it's 14. So this should be 14 and future prospect should be 25%.
So multiplier should be 14.
Multiplier should be 14.
And not 18.
No. So this is regarding the multiplier. And now coming to the issue of non-pecuniary, my lord. It's a case of amputation, no doubt. It's very sad. But what happened? The learned trial judge, my lord, had granted 10,80,000 on the head of loss of funding capacity. At page 41, my lord will kindly see another compensation was awarded, that is for inability of petitioner or injured to earn. So these two heads, my lord, they are the same.
Okay.
Page 41, compensation for inability of petitioner or injured
That is
to earn.
1,50,000.
That is 1,50,000.
Okay, that is
extra additional.
Monetary loss is there.
Yes, and over and above.
It should be non-pecuniary.
In my humble submission, this
loss of earning capacity.
Yes.
And non-pecuniary, the others, medical expenses,
Yes.
pain and sufferings.
Medical expenses is also
Pecuniary.
pecuniary. Pain and suffering, transportation, loss of comfort and amenities, these are non-pecuniary.
1,50,000 second time.
Second time. And the last ground is, my lord, this so the last round is, my lord, interest. 9% interest was awarded. I humbly pray before my lord, let it be 6%. So these are my 4-5
You
rounds.
are challenging both the involvement as well as the quantum.
My lord.
Quantum on the ground that this is granted again 1,50,000.
Yes.
And the multiplier.
On the ground of income, multiplier, non-pecuniary and interest. Income, multiplier, non-pecuniary and interest. This is all, my lord.
Yes.
Thank you.
My lord, I have prepared on short notes along with list of dates. Your lordship will find from my notes, first page, my lord, a list of dates are there, important list of dates. First, my lord, the accident happened on 28th November 2017. My lord, on the same day, injured, my lord, hospitalized at Primary Health Center, Mohanpur, Paschim Midnapur. My lord, on the same day, he was shifted and hospitalized at Vivekananda Hospital, Bhubaneswar. On 28/11.
Sorry. One more thing, my lord. The age, my lord, will, I'm sorry to interrupt, my lord. In their claim application, my lord, it says 40 years. So, it cannot be 35 years. It has to be something between 41, 42, something like that.
40 years also,
That
then
is
14 or 15?
No, that is 15.
40 years. Yes.
My lord, he was hospitalized at Vivekananda Hospital at Bhubaneswar from 28th November till 3rd December.
Yes.
And my lord, on next day, he, my lord, again hospitalized at Krishna Hospital, Cuttack. And on and from 4th December to 18th December, he was there at Krishna Hospital, Cuttack, where, my lord, his right leg has been amputated in Krishna Hospital. My lord, after the discharge, my lord, he, my lord, came to his residence and took rest. And, my lord, he himself on 4th January went to police station and lodged that FIR. Your lordships kindly come to the FIR. Page 56, already your lordships perused. Here, my lord, page 56, the written complaint before the police.
Yes, yes.
From the middle portion, মোটরসাইকেলটি নিয়ন্ত্রণে রাখতে না পেরে আমার ডান পায়ের উপর দিয়ে মোটরসাইকেলের পিছনের চাকা চলে যায়. Have you also got it at the middle portion of page 56, exhibit 2?
Yes.
At the middle portion, my lord, মোটরসাইকেলটি নিয়ন্ত্রণে রাখতে না পেরে আমার ডান পায়ের উপর দিয়ে মোটরসাইকেলের পিছনের চাকা চলে যায় এবং মোটরসাইকেলের চালক মোটরসাইকেল নিয়ে পালিয়ে যায় এবং ডান পা গুরুতর জখমপ্রাপ্ত হয় এবং সারা শরীর রক্তাক্ত হয়ে যায় এবং যন্ত্রণায় আমি চিৎকার করলে স্থানীয় লোক ও পথচারী চিৎকার শুনে ছুটে এসে আমাকে অ্যাম্বুলেন্স করে মোহনপুর বাগদা ব্লক প্রাথমিক স্বাস্থ্য কেন্দ্রে ভর্তি করান. ডাক্তারবাবু প্রাথমিক চিকিৎসা করার পর শরীরের অবস্থা সংকটজনকভাবে উন্নতিমানের জন্য চিকিৎসা কারণে অন্যত্র নিয়ে যাওয়ার সুপারিশ করলে বাড়ির লোকেরা উড়িষ্যার রাজ্যের ভুবনেশ্বরের বিবেকানন্দ হাসপাতালে ভর্তি করান. গত 28/11/2017 তারিখ থেকে 3/12/2017 তারিখ পর্যন্ত চিকিৎসা হই, কিন্তু চিকিৎসার কোনো উন্নতি না হয় বাড়ির লোকেরা কটকের কৃষ্ণা হসপিটালে ভর্তি করান. গত 4/12/2017 তারিখ থেকে 18/12/2017 তারিখ পর্যন্ত চিকিৎসা হই, কিন্তু ডাক্তারবাবু যথাসাধ্য চেষ্টা করেও ডান পা জোড়াতে না পারায় দারুণ বাধ্য হয়ে ডান পায়ের হাঁটুর নিচের অংশ কেটে বাদ দেন. ডাক্তারের চিকিৎসাধীন থাকার দরুন আপনার থানায় জানাতে দেরি হইল. অতএব মহাশয়ের নিকট বিশেষ প্রার্থনা যে সরজমিনের তদন্তপূর্বক উপরোক্ত মোটরসাইকেলের চালকের প্রতি আইনানুগ ব্যবস্থা গ্রহণ করতে অনুরোধ জানাই. This is the fact, my lord, and the delay from the date of incident to lodge the FIR only 34 to 35 days. My lord, he has explained the cause of delay in the written complaint, and he himself lodged the FIR. It is not the case that his family members or any unknown person from the road went to police station and lodged the FIR. Your lordships kindly visualize who, my lord, got amputated on his right leg, on vital portion of his body. He himself, my lord, after, my lord, when, my lord, he reached to police station, lodged the FIR and specifically mentioned the vehicle, offending vehicles number in his written complaint. On the basis, my lord, the police started investigation and seized the motorcycle. There is no dispute. My lord, the insurance company, after being noticed, my lord, being summoned, they appeared and filed their written statement, my lord. I could not find anything from the written statement filed by the insurance company that they have taken any pleading in specific.
The vehicle owner filed written statement?
No, vehicle owner not appeared and contested the case. Normally that done, my lord, in the trial court, my lord. Whatever may be, my lord, the insurance company appeared and filed one application under section 170 of the MP Act to
Owner filed written statement.
But lastly
Page
disappeared
30.
from the
Page?
30 of paper book.
My lord,
The award.
no, my lord, I'm sorry, my lord. Owner appeared, filed, and thereafter, my lord, disappeared.
Page 30.
Page 30.
30 is the judgment.
It's a judgment, my lord. It says owner filed written statement, but ultimately did not contest.
Have you incorporated that?
No,
The-
I could not find.
LCR আছে এখানে?
LCR, দাদা LCR টা আছে? LCR টা, এর LCR টা
হবে হয়তো এখানে। হ্যাঁ আছে তো।
আছে, একটু মাইনাস আমি কাছে আমি বার করি। After filing written statement, they disappeared from them. That is their technique in the trial court. They adopted in every case, and few cases, my lord, they, my lord, contested.
লিখেছে তো, তাহলে হয়তো ভুল লিখেছে, না এক লাইন হবে ছোটখাটো।
I could not find the record.
देखिए record
Maybe wrong recording, maybe.
नहीं okay.
And thereafter, my lord, they disappeared. Either my lord not appeared, or my lord, if they filed, thereafter, my lord, they disappeared from the court to avoid the proceeding. Well, the insurance company filed their written statement. Subsequently, they have not filed any additional written statement to the court. My lord, issues framed on that aspect. They have not taken any specific ground regarding non-involvement of the vehicle or any other vehicle in the accident. Even, my lord, regarding delay in lodging the first information report. Even, my lord, they have not specifically challenged, though not permitted, not challenged the same before at the time of trial to any witness. Even, my lord, question was put, specific question was put to the eyewitness in that respect. Even, my lord, they have not come with a specific eyewitness of the occurrence or not produced any specific documents to substantiate their claim before the learned tribunal that the since mere because delay in filing FIR does not negate the claim case. They have to show in absence of the vehicle owner that there is some foul play. Other vehicle has been implanted in this case. They have not taken any steps in the trial court. And 34 days only, and the person injured, he himself, my lord, lost the FIR from the date of incident after 34 days, after amputation of his right leg. And no case made out specifically by the insurance company before the trial court in that respect. So I think, my lord, I need not, my lord, more argue on this aspect, my lord. My lord, regarding the quantum, my lord, your lordship, I have, my lord, also annexed the judgment of Ravi versus Badrinaran on the point of, my lord, delayed filing in FIR. And, my lord, one judgment, my lord, that is, my lord, the well conversion judgment of Govind Jadhav versus New India. This is, my lord, on the aspect of how, my lord, the pecuniary, non-pecuniary damages to be calculated. But here, my learned friend, my lord, already submitted before your lordships that 1,50,000 given second time or further under the heads of pecuniary, though. Pecuniary. Non-pecuniary. Pecuniary.
Whatever you say.
Because, my lord, the learned tribunal calculated the income once, then, my lord, further admitted 1,50,000 more. Here, lordship, your lordships kindly come to page 40 first. Page 40 of the judgment. This is the judgment operative portion of the award. Page 40, inner
Yes.
page 13 of the judgment.
Yes.
My lord, this is the middle portion. Computation of compensation amount. The victim, Surchandra Vikas Jana, was working in a private factory with monthly income of rupees 10,000. Undoubtedly, amputation of his right leg impaired his free and normal movement and thereby badly affected his personal and professional life. Thus, monthly salary of rupees 10,000 per month is fixed. The annual income of the deceased was rupees 10,000 into 12, rupees 1,20,000 annual, which is not taxable under the rules of income tax. Multiply. My lord, here towards future prospect, that is 50%, 10,000 into 12, 50%, 60,000. Only 60,000 awarded on account of future prospect. I am coming later on that. Loss of earning 10,000 into 12 into 18, and everything wrongly calculated by divided by 50%.
That is loss of earning capacity.
Loss of earning capacity. Thereafter, your losses can come. The finding. The victim almost required 1 year time to return to his normal life due to sufferings caused by serious leg injuries followed by amputation. My lord, here, my lord, in Govind.
No, which page, which
My
paragraph?
lord, just after that line, my lord, after calculation.
No, this is
10,000 into 12 into 18 into 50 by 100 comes 10,80,000. Thereafter, my lord, the victim almost.
yes.
The victim almost required 1 year time to return to his normal life due to sufferings caused by serious leg injuries followed by amputation. This is the finding. So, maybe they are, my lord, double calculation. But on this head, my lord, the learned tribunal, my lord, came to a definite finding, but not granted any compensation under that head, my lord. That head means the loss during the period of treatment and thereafter, my lord. He will not return to his normal life for a period of 1 year after the accident. That finding is there. But no amount has been awarded, and learned tribunal on that prerequisite, my lord, awarded 1,50,000. I am submitting here, my lord. So no deduction from the total calculation can be made. Here, my lord, in Govind Sharma, yes,
Govind Yadav.
Govind Yadav, your losses will find my lord, your losses kindly to Govind Yadav judgment. I have already given, my lord, in my notes, my lord.
Govind Yadav.
Page. If, my lord, it is reported from Supreme Court cases, page 692.
Page?
So, page 692, para 17, subpara. Subpara 6. Have you got it?
Para, subpara?
Subpara, my lord.
Yes.
6.
The heads under which compensation is pecuniary damages.
Personal injury cases are the following: pecuniary damages, special damages. 1, 2, 3. 1, 2. 2, my lord, loss of earning and other gains which the injured would have made had he not been injured, comprising A. Loss of earning during the period of treatment. Here, my lord, it is evident from the records, my lord, the after amputation, my lord, is normal. He was treated thereafter for a long, and it is also came to the evidence, no challenge. Very normal. After very vital portion of his body, my lord, amputated. So, learned tribunal rightly, my lord, found it, but not granted any heads. My lord, granted 1,50,000. I am submitting, my lord, on that head, my lord, learned tribunal granted 1,50,000. Whatever maybe, my lord, 10,000 to 12, my lord, 1,20,000, that is separate thing. Your lords will consider that, but that should be, my lord. That should be.
That means inability to earn during the period of treatment.
Yes, treatment means, my lord, not during, not till amputation, even after amputation.
So what is that evidence that after amputation, he could
Amputation,
not
my
work
lord,
for 1 year?
This is, my lord, obviously in between the period of treatment. Amputation should be done in the meantime. In the meantime, my
That means 1 month or 2 months.
whatever may be, even, my lord, after 6 months, doctor may find, my lord, the amputation has to be done, otherwise he will die. That is separate thing. And even after amputation, my lord, the further necessary, my lord, the follow-up is required for his further
Anyway,
treatment. That is the
medical
future,
expenses,
medical
present, future is also granted.
future not granted.
Future not granted.
Not granted. That is, my lord, I am pointing out this. I am coming on that, my lord. I am coming. My lord, this I will show further.
Total compensation awarded how much?
20 lakh something. 20 lakh something.
Yes.
Regarding age,
2023522.
2023.
23,522.
20 lakhs, 23,000 what?
Anyway, your ground of challenge is future prospect.
Future prospect.
So that is your ground of challenge.
And 10,000 my lord granted, your lordships kindly
10,000 income considered.
income 10,000 is considered. Whatever may be the evidence and documents, document is nothing, my lord. The employer himself came to the dock. And my lord, what is the evidence, my lord? Your lordship kindly come. কত নম্বর কথা এটা?
22
না ওই এভিডেন্সটা আছে
22
22 page 22. Your lordship kindly came to page 22 of the paper book. That is the evidence of Chandan Bera, PW4. He is the employer of the Surjendu because Jana, who is the victim injured in this case. My lord, his evidence is like that. Have your lordship got it? I have received someone to appear to depose in this case. I am a contractor. My business is under name and style Mahakali Enterprise. There is original trade license of my business for the year 2022, 21, 20. These documents bear seal and signature of Nilda Gram Panchayat. This is the receipt showing deposit of trade license fee for the year 2019, 18 and 17. This is the original registration certificate of 2020 issued by Nilda Gram Panchayat. Let the documents mentioned above be marked as exhibit 14 series. I know Surjendu Vikas Jana was an employee of my business. This is the certificate issued by me on 9/10/2018, stating that Surjendu Vikas Jana used to receive monthly salary of rupees 10,000 per month. This is my signature on the certificate issued on the letterhead and on my business, letterhead of my business. Let the document be marked as exhibit 15. Cross. Surjendu Vikas Jana worked in my business since 2015 for a term of 2 years. I did not maintain any register for the employee who worked in my business, nor there is any register showing payment of salary to every employee on each month. He was regular in his attendance in office. There is no document to show that he is receiving salary of rupees 10,000 every month. I maintained income tax file of my business. Recently, I have stated the provision of paying for the employee of the business. It is not a fact that Surjendu Jana was not an employee in my business. It is not a fact that he was not receiving salary of 10,000 per month. It is not a fact that I have manufactured the certificate in my declarement. My lord, the employer himself came to witness box and my lord deposed after being summoned by the court and deposed in that effect, to that effect, my lord. Now, your lordships kindly come. The question was put during cross-examination by the company during trial was in specific in that, have you maintained income tax file of your business? He told before the court, yes, I maintained the income tax file, but never questioned by the company lawyer that could you produce the income tax return before the tribunal in the next day. No specific question was put to deposit all the documents you filed to prove your business. No specific question. So, in view of the Evidence Act, my lord, they cannot take benefit of that. So, the witness was not bound to produce all the documents because he was not asked to produce all the documents in view of Evidence Act. He was not asked to produce all the documents, PF file, IT file, or business other files. Is not the case that any employee of the company being representative of the company, my lord, given evidence. The employer himself came to the place before the learned tribunal. Learned tribunal examined himself. My lord, the second thing, and 10,000 rupees, my lord. It was not exorbitant, not 25,000, not 50,000. So a reasonable amount he claimed that he paid. And the claimant also, my lord, on the same way from the very beginning, from the claim application, he also, my lord, in specific rupees, in column 6, page 1, rupees 10,000. And my lord, he mentioned his employer's name, Messrs. Mahakali Enterprise, government contractor and general order suppliers, at PO Gomunda, PS Mohanpur district, Paschim Medinipur. In specific, from the very beginning, from the very first day, he was in specific on that point. It was not a case that, my lord, he claimed a exorbitant amount, unreasonable amount. A person, family man,
Yes,
cannot.
what is the cross-examination put to this
Yes, my lord, I
PW1?
have already showed your lordships.
PW1.
PW1. PW1, your lordships kindly come to page. Your lordships kindly come. Page 16. Page 16. This is the
No,
cross.
page 11.
Page 6. Page 16.
16.
Cross-examination of PW1.
Okay, okay. Yes.
I shall cite witness in my favor. I was treated at Vivekanand Hospital. From there, I was transferred to another hospital at Calcutta. I have spent 4 lakhs for my treatment. There is no document showing my monthly salary of rupees 10,000. I have Aadhaar card to prove my age. I have accident occurred. My accident occurred on 28 November 2018. After amputation of my right leg, I have to go for follow-up treatment. I was walking through the Muram portion of the pitch road. I was dashed by the vehicle while I was walking. This is not a fact. I deposed falsely regarding my age and income as well as medical expenses of rupees 4 lakhs. I had to go by hiring vehicle for 6 months for dressing of my wounds after amputation of my lower limb, my lord. This is. It is not a fact that I was not working at Makali Enterprise. It is not a fact that I deposed falsely that the accident occurred due to fault on the part of the driver. The driver dashed me from behind, my lord. Thereafter, my lord, your lordships will found that, my lord, during pending of the appeal, my lord, before this honorable court last year, the Sujanta Vigajana expired. So her family member, one daughter, one son, and wife, my lord, implicated in this proceeding as party of the proceeding, and my lord, the order, my lord, your lordships passed that order. They are all major. So family man, he was family man. So it is not that he was bachelor. He family man. So 10,000 very reasonable. It cannot be disputed in this regard. When the employer, most of the cases your lordship will find the employer will not come. Normally employer is not coming in the court even after being summoned. Here in this case, my lord, the employer came. From the very beginning, my lord, the details of employer has been mentioned, has been disclosed by the party. My lord, the second point, my lord, future prospect, my lord, only granted 60,000. It should be what would be the calculation, actual calculation. If your lordship takes it 10,000, then 10,000 should be multiplied by the actual multiplier, and my lord, 40% should be, my lord, because the learned tribunal, your lordships kindly come.
Yes, where age of 41,
40
future prospect 40.
25%.
25. The tribunal did not grant future prospect.
Did not grant. It court learned tribunal 34 বছর ধরলো কেন? Exhibit 13.
আধার কার্ডের বেসিসে।
আধার কার্ড যাবে না?
না, সুপ্রিম কোর্ট বলে দিয়েছে।
কি যাবে তাহলে? ভোটার কার্ড?
Birth certificate, school leaving, na. Jokes apart. Aadhaar card cannot be taken to be
claim cases.
Yes, in all cases, in motor accident claim cases also, Aadhaar cannot be taken to be the strict proof of age. It has to be the birth certificate, school leaving certificate, or Indian passport, PAN card. Aadhaar is only for identification. Supreme Court has
any other documents filed except Aadhaar
no,
card?
the medical records are there which say 41, 42.
Suppose your lordship.
No, it is the case of the claimant that he is 40 years
He is 40.
He mentioned in the claim application.
Yes, so what more is required? He cannot go beyond his own pleadings.
40 years, if it is taken 40 years,
Yes.
then future prospect should be 40%.
Is it so?
Yes, my lord. This is after 40 years, my lord, more than 41.
It comes.
Then 25%.
It comes to 41.
No, my lord will kindly come to Pranay Sethi. Less than 40. Less than 40, that is 40%. My lord will come to Pranay Sethi. এই যে দেখুন, আমি জানি এই ইস্যুটা উঠবে। এই যে Pranay Sethi, my lord, it says, accept. In case of deceased was self-employed or on a fixed salary, an addition of 40% of the established income should be the warrant where the deceased was below the age of 40 years.
My lord, take it 25%.
I'm grateful, my lord.
25%.
To my learned friend.
না না যা আছে আইন আমি তার বাইরে বলবো কেন আমি কি শৈবালন্দু ভৌমিক নাকি
Personal attack.
my lord 25% and my lord তাহলে কি এজ কত ধরছো তাহলে মাল্টিপ্লায়ার
You
কত
cannot, you see, claimant cannot go beyond his own pleadings.
Yes.
He cannot take a contrary stand.
My lord may be wrong.
Anyway, 40, let it be 25%.
I'm not disputing this. Maybe my
So let us proceed on for 25%.
আর ওইটা এজটা 40 যদি হয় তাহলে কত
It's better, you see, you proceed in your own way, give your calculation on the basis of 25%.
And the age,
And
the multiplier,
whatever it is, if the multiplier has to be
considered
accepted.
age to be 40.
40 means that is 14 probably.
No, 15.
15. So,
25%.
so you give your own calculation
My
on
lord.
the basis of future prospect and whatever is awarded by the trial court,
My lord.
except that multiplier.
Multiplier and the,
And you also give your own calculation,
My lord.
considering that 1,50,000.
and
So your challenge is that 1,50,000 should be.
1,000, my lord. And the non-pecuniary portion is total 5,50,000. In my calculation, will I be adding?
Anyway, you give your calculation.
Lord. Or I'll keep it blank, that portion. The non-pecuniary, total non-pecuniary. I'll leave it to my lord.
Yes.
And my lord
Now you give your own calculations. You have argued on the, you have argued with regard to involvement, with regard to monthly income, with regard to that 1,50,000, with regard to multiplier. Now give your calculation. Let me consider her calculation. Then thereafter I shall try to reconcile whatever it is.
My lord, one thing, my lord, I shall calculate on my own way.
Yes, yes. You see, your deviation from the learned trial judge is only with regard to that future prospect. Other contents you are not disputing. So you submit in your own way. You give your calculation in your own way.
এখনই দিয়ে দিচ্ছি হ্যাঁ ঠিক আছে
And I will pass the judgment on some other day.
my lord thank you এটা করে দাও আমার নাম condense করে দাও No compensation has been awarded on account of expenditure of life and nourishing foods.
Anyway, that you have not challenged.
It is in Govind Jadav's judgment. That is why, my lord, I am
Question is you give your judgments as well as give your calculation, because your ground of challenge is confined to that 40%. You have said 40%, but it should be 25%. There are other grounds. There is no other grounds taken.
No. করে দিচ্ছি পরিষ্কার করে লিখবে My lord, one thing, my lord, ability certificate came at the rate of 50%.
That is considered.
That is considered. But the fact is, the employer also admit that after the amputation, my lord, he is not working under him. And my lord, the claimant himself before the tribunal deposed in that line, my lord, he is not in a position to do any work after that, my lord. Because if one leg's gone, but he will be in scratch.
He has to go and sit in a shop,
Yes.
only as a shopkeeper.
Shopkeeper, my lord. After my lord putting scratch, my lord, who will give job him?
No, only his own job has
Own job, but
own
he is
shopkeeper.
not, my lord, he has no shop. That is not the evidence. So 50% not maybe 100. Supreme Court already specifically observed in other cases. It cannot be 100. 100, my lord, the special
No,
cases.
depends upon the nature of occupation. For
Yes.
example, a driver.
Driver.
He is handicapped, one leg gone, no question.
No question, 100.
But if a consultant or something like that, even with one leg, he can work.
But he was
Or
working.
a doctor also, with his one leg, to some extent, he can give medical advice.
Yes, my lord. But the person, my lord, in question, he was working under the employer, my lord, working a job.
But he was not a mason after all.
Not mason.
Okay, mason, yes.
But it cannot be 50, it more than 60, 70.
So whatever is the disability certificate
yes, produced. It is already on record.
So that has to be
50%. 50%. But he was on scratch.
Yes,
That
depends
is the
upon. That
problem,
is
my
why
lord.
the decision says that
I
on the nature of occupation.
I have also challenged in my grounds that not 50, not 100, not even not, my lord, it cannot be taken as 50.
Anyway, you give it in your own calculation, in your grounds.
But and my lord, your losses, when will grant, my lord, any compensation, your losses kindly direct the office of the Learned Registrar General to disburse the amount to the present claimants. Now the family members implemented as party, my lord.
So these are already on record.
Already on record.
The claimants.
Instead
Claimants,
of claimant, injured claimant.
Claimants appellants.
Claimants, respondents.
Number 1 to
1 to 3.
1 to
Respondents, my lord.
Yes, claimants
We are
respondents 1, 2, and
in this
3.
appeal, my lord. She filed appeal. I filed on cross objection. And my lord, the one order may be recorded, my lord. The cross objection is not appearing in the list, my lord. Cross objection is, but in the record, my lord, cross objection is there, my lord. So on our consent, my lord, the cross objection is also, my lord, treated to be days list, and my lord, your loss is hard disk.
না রিজার্ভ করব হ্যাঁ এটা কবে ইয়ে নেক্সট উইকে কবে জাজমেন্টের ডেট ফাঁকা আছে 28 না 29
reply to what the judgment of Govind Yadav, my lord. It was 70% disability and a total sum of rupees 3,50,000 was granted on the head of non-pecuniary. And in this case, it's 50%. I understand it's a case of amputation, my lord, but
depends upon the nature of occupation.
yes, in Govind Yadav, that's also a case of amputation. It was 70% disability and a total sum of rupees 3,50,000 was granted for non-pecuniary. And here in 5,50,000 has been granted. Non-pecuniary.
This 1,50,000.
I have not added that. In my calculation.
No, here it is stated to add 1,50,000 for loss of comforts and amenities.
Yes.
That is there.
That is there. That is there. 2 lakh for pain and suffering, 50,000 for transport charges, and 3,33,552 for actual medical expenses.
So actually, that 1,50,000 you have deleted.
I have deleted.
You have considered the future prospect as 25%.
Yes.
And the multiplier as 14.
15.
50.
40. May I just write down that this is a calculation for the appellant? I'll just write it down. আমাকে একবারই কাগজ
এটা দিন তো
আমাদের
I have already submitted.
Yes, record an order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 1/8/2026.
My lord.
So you have any objection?
No,
I don't have any objection.
Saturday. But your lordships already fixed on my matter.
Okay,
on
oh,
that
judgment?
day. I shall come.
No, another judgment I've also fixed.
We both will come. Grateful, my lord. Deeply
Oh.
obliged.
Mr. Singh is my other side in that matter, my lord.
Yes, definitely.
Will
No,
also-
he will come.
মৃণাল দা তুমি এদিকে এসো এইটা পেপার বুক কোথায় অমিত দা?
বিরিয়ানি খেতে যেতে হবে।
তাই।
আজ শনিবার
এই যে এইটাই যেটা হুম, হুম। 471 আছে অনলাইনে আছে না না জাস্ট ডিসমিসাল কেস ব্রাউনটা জাস্ট এক
Yes,
মিনিট
you are for the.
আই এম ফর দি রেসপন্ডেন্ট মিস্টার রয় ইজ ফর দি
Well, let me see the order under appeal.
it's a dismissal case my lord 163A but the reason is
It's a ground dismissal.
it says that victim was traveling in a bus at the time of accident
Yes.
and learned trial judge held that it was not proved that the victim was traveling in the bus at the time of accident but the FIR and charge sheet it's against me and the widow lodged the FIR
So there is no eyewitness, only the widow.
only the widow and
And
FIR
only the widow is the witness.
against me
Must you kindly come to page 33? Lordship, am I audible?
Yes.
Lords. Lordship, kindly see page 33. the observation of the learned tribunal, it is true that the case under section 163A of the MB Act, and as such, it is not required to prove by the petitioner that the alleged accident took place due to the rash and negligent driving on the part of the driver of the concerned vehicle. So, Lordship, the vehicle was used and involved, that has been proved by the state investigation authority, and charge sheet has been submitted against the driver. Lordship, kindly see that is not at all not required. Lordship, kindly come to the charge sheet at once. Charge sheet page 23. So kindly see the particulars of witnesses to be examined. Monju Hazra, that's the one of the appellant claimant. And then Lordship kindly see 5. Siddhartha Ghosh. Lordship kindly see Monju Hazra residing at Lordship Alampur, Hazrapada. And the number 5, Siddhartha Ghosh, also the same address. And Lordship kindly see 6. Sumon Mondol, also residing same address. Lordship kindly see, then 10, SI of Pradip Kumar Roy, this is the UD case, has been lost. So this is the officer of the UD case, unnatural death case. He also been examined. After that, Lordship kindly see the brief fact of the test 24, the IO also, Lordship consider the brief facts. Lordship kindly come to the 1, 2, 3, 4, 5, 6, 7. After 7 lines, Lordship will found he was fell down from bus behind the door due to rash and negligence driving by the driver of the said bus. So the state investigation authority has proved my case and also support my case that my husband died due to the fell down from the bus. But Lordship, aware that the law under section 163A is not required to prove the manner of accident. Let's you kindly see that the observation of the learned tribunal thereafter, page 33. Page 33, second paragraph. As you know, gossip.
Yes.
Yes, it is true that, second paragraph, it is true that certified copy of the FIR charge sheet in connection with the Bhatar PS case number 358 of 2013, dated 7/11/2013, have been marked as exhibit number 2 and 3 respectively. But those documents are not substantial piece of evidence and do not prove the petitioner case. Again, that observation, with due respect to the judiciary, that observation should not be made by the learned tribunal. From the charge sheet submitted, is found that the IO examined many witnesses in such a situation, the petitioner could not examine the witness examined by the IO. So it is not at all not required. It's a case under section 160A, Lordship. So Lordship, kindly, if Lordship kindly go through the section 163A at least once again. So I'm reading this statute once again. The notwithstanding anything contained in this act or any other law for the time being in force or instrument having the force in law, the owner of the motor vehicle and authorized insurer shall be liable to pay in case of death or permanent disablement due to accident arising out of use of motor vehicle. So the vehicle has been used. That is not denied. And Lordship, I am just placing the witness. One witness is there. Monju, the insurance company did not also put the question in such way because of the award that the 163A that evidence is at all not required. Just kindly turn to page 17. Cross-examination. Second paragraph. Plus, you kindly see, I read it up to class 8, lost FIR, charge sheet. I cannot say what form. After the insurance company did not put any question the manner of accident because of it is the law. For the reason they didn't put the question what is the manner of accident because under section 163A said from the side of the insurance company did not challenge the situation. They accepted the situation.
Yes,
May I-
what is the written statement of insurance company?
Yes, Lordship, kindly turn to page, it starts from page 6. They are challenging the income, age, the usual challenging, just denial the entire case in such a, but they did not raise this issue regarding the issue as issue raised by the land tribunal and pass the judgment. That one is not there, subject to fashion lordship. Lordship, kindly turn to page 8, paragraph 10. They denied the income, age. The 160 year nowadays, Lordship, income is not the issue. All under that score, insurance company did not also put this question to the petitioner. I mean to say the one of the claimant.
Yes, just a
My lord will kindly see first information report. It goes against me, but still this will shorten the matter, my lord. First information report, it's at page
Page 19.
page 19. The relevant portion, my lord, page written complaint is at page 19. That has been lodged by the widow. And the widow says that her husband was traveling in the bus, and when the bus suddenly stopped, he fell down. Thereafter, on the basis of this, the charge sheet was produced, filed by the police. That is at page 24, the observation of the police authorities. Page 24. This will make the matter absolutely short. Of course, it goes against me. Page 24.
Page 19 is the FIR.
FIR.
Which states about the accident as well as the vehicle number.
Yes.
Yes.
And 24 is the charge sheet, my lord.
Page 24 is the
yes, the charge sheet.
Last paragraph.
Is it
page 24.
legible, my lord?
Yes.
LCR. And page 25 is wherein the driver has been charge sheeted under section 304A. The post-mortem report is also there. That is at page 27.
Page
It
27.
does not mention anything about road traffic accident, but it's there. It's there. He died on 27th of October.
An incident took place
On 24th.
24th.
He died on 27th.
On 24th of October, the incident took place. So this is the entire case.
And after how many days FIR was lodged?
FIR was lodged on 7th of November.
7th of November.
Yes, Lordship, because he was in the hospital.
7th of November. He died on 27th. Thereafter, after performing the
rituals,
it was on 7th of November by the widow.
And that explanation given in the FIR complaint that he was busy with some rituals.
As it is 163A, no evidence was adduced by the insurance company. No involvement of the vehicle was denied.
It was denied.
Only rash and negligence in the driving was denied.
Yes.
It was a
General denial.
General denial.
Where is this PW1 page?
Page 14.
W1 page, Your Lordship. Page 14.
14.
The cross examination is at page 17. 17.
Yes, take down.
And one majority, they have, Mr. Roy had filed one.
Yes, Lordship. I have filed one application for attainment of majority. Lordship, kindly added one line that applicant number.
Okay. Learned advocates for the parties are present. The application being can item 34.
This is item number 68.
68.
68.
Can 2.
Yes.
Then 1 Turkey.
Appellant number 2 and 3 attain majority.
Application can 2. Can
Yes.
2 of 2026.
Lordship.
By the appellant number 2 and 3 on the ground they have attained majority is taken up for consideration. Upon hearing the learned advocates and upon perusing the petition, the application stands allowed. Let the majority of appellant number 2 and 3 be recorded. By consent of the learned advocates, the matter appeal is taken up for hearing. Heard learned advocates for the parties. The appellants before this court were the claimants in a case under section 163A of the Motor Vehicles Act 1988 and are aggrieved by the judgment and award passed by the learned additional district judge, Second Court Purbo Bardhaman, in MAC case number 57/351 of 2013. Top. The case of the appellant's claimants before the learned trial court may be summed up thus. On 24/10/2013, at about 2:30 p.m., the victim Mintu Hajra was traveling by a bus WB41 capital A -4973. Within bracket, he sat on the back door side seat of the bus, bracket close, which was proceeding rashly and negligently, and the driver used sudden brake along the Gushkora Barwan Road, NH2B, near Ambona Notunhat Culvert. Stop. Due to rash and negligent driving, the said victim was not able to keep his balance and fell down from the bus. Stop. As a result, he sustained severe injuries and it caused his death. Stop. Rash and negligent driving on the part of the bus was the sole cause of the accident. Stop. A complaint was lodged and police authority started case against the driver of the bus under section 279/304A of the Indian Penal Code. Stop. The victim, since deceased was a person of active habits and had all qualities to prosper in his life in the near future. Stop. The wife of the victim lost consortium at her prime age due to the accident, and the applicants are passing a life of uncertainty. Stop. Pursuant to filing of this case, notice was issued upon the opposite parties. Stop. Opposite party, vehicle owner, did not contest the case. Stop. Opposite party, United India Insurance Company Limited, contested the case by filing written statement. Stop. Issues were framed and evidence was adduced. Learned trial judge, upon considering the evidence and upon hearing the learned advocates, was pleased to dismiss the claim case by observing and directing as follows. এখান থেকে হ্যাঁ page 33 এখান থেকে set out. The claimant's appellants, being aggrieved by the judgment and award passed by the learned trial judge, has come up with the instant appeal. Stop. Heard learned advocate for the appellants, claimants, and learned advocate for the respondent number 1, United India Insurance Company Limited, produce the evidence adduced and materials on record. Learned advocate for the appellant submits that the learned trial judge erred in dismissing the case under section 163A of the Motor Vehicles Act 1988. Stop. Learned advocate further submits that the FIR and the charge sheet submitted by the police authority was sufficient for consideration of the claim case filed under section 163A of the Motor Vehicles Act. It is also submitted that as 163A is with regard to the principles of no fault liability, a strict proof of rash and negligent driving is not required. Learned advocates for the appellant, respondent number 1, insurance company, disputes the submission of the learned advocate for the appellant. Upon considering the facts of the case and the fact that the case was filed under section 163A of the Motor Vehicles Act 1988, which deals with the principle of no fault liability, this court is of the view that considering the statements made by the opposite party insurance company in the written statement and the fact that the vehicle owner did not contest the case, and the fact that considering the FIR, the police authority conducted investigation and submitted charge sheet, was a ground to allow the application under sections 163A of the Motor Vehicles Act 1988. In different cases where it is not possible for the families of the victim to ascertain the witnesses of the accident, the victims of the family has to depend upon the police report to file the claim case. In case where the police report and the FIR and other materials on record inspires confidence in the minds of court, the court is not powerless to consider and award compensation in claim cases, specifically under Section 163A of the Motor Vehicles Act, where it is based on the principle of no fault liability and rash and negligence of the vehicle driver is not required to be proved. Upon considering the fact that motor vehicles claim legislation is a beneficial legislation, and considering the principles laid down under Section 163A of the Motor Vehicles Act 1988, and considering the written statement filed by the opposite party insurance company and the evidence adduced by PW1 and the charge sheet submitted by the police authority, this court is of the view that the claim under Section 163A of the Motor Vehicles Act ought to have been allowed. Stop. Hence, this appeal, FMA 471 of 2020, stands allowed. Acha. Thus, however, with regard to the quantum of compensation, although the claimants have stated the income of the victim, but considering at this stage that necessary amendments are made in the Motor Vehicles Act, in which Section 164 of the said Act provides that compensation of ₹5 lakh is to be provided to the claimants stroke victims of motor accident uniformly, it would be just and reasonable to award compensation of ₹5 lakh to the claimants appellants. Stop. Hence, this appeal FMA 471 of 2020 stands allowed. The judgment and award dated 19th August 2016, passed by learned Additional District Judge, Second Court, Purbo Bardhaman, in MSC case number 57/351 of 2013, is set aside. The appellants claimants are entitled to compensation of ₹5 lakh from the respondent number 1 insurance company, along with interest at the rate of 6% per annum from the date of filing of the claim case till today. The respondent number 1, United India Insurance Company, shall deposit ₹5 lakh along with interest at the rate of 6% per annum within 8 weeks from the date of communication of this order. Stop. The appellant claimants will be entitled to withdraw the compensation upon compliance of the necessary formalities.
Also with equal share.
It is hereby clarified that the compensation shall be withdrawn in equal shares.
And lordship, the court fees already been paid. That is appearing from the judgment. Lordship, can you record that the court fees paid?
How much did you
pay? Judgment.
No. Enhanced compensation?
No, lordship, there's a dismissal case, so no enhancement, nothing.
Oh, it is not necessary then.
Lordship, it is appearing from the judgment. Lordship, kindly see the court fees sufficiently paid. It is appearing from the judgment.
I am not recording anything.
And lordship, kindly record one thing, lordship, November 2013 case was filed. Can you record the filing date?
It's not
I'm
necessary.
grateful, my lord. Deeply obliged.
Yes.
Deeply obliged.
I'm obliged, lordship. I'm deeply obliged, lordship.
PM.
চার কি আছে ওই আরটা কি ওই যেটা না
Item number 8, my lord.
Yes, you are for the appellant.
I am for the appellant and my senior friend is for respondent. My lord. Enhancement, my lord. So the service upon the respondent owner of the vehicle, respondent 1 may be dispensed with. My lord. No, no.
Contra.
Is my lord, the contents of the two paper books are same. The supplementary paper book filed latest, it contains the correct cost title. That is the only difference. Otherwise, my lord, contents of the paper books are all same, my lord. No, previous in the previous bench it was another was 5. Dharamshila Devi is a present cost title. Appellant. So my lord, very short matter, my lord.
Yes. What is the matter about?
My lord, matter is for enhancement.
Well, is it an injury case?
No, my lord, death case, my lord.
Yes.
Death case, my lord, it is a
My lord, page 22 is the judgment.
22, my lord, page 28. 28 is the operative part, my lord.
Operative part, my lord.
Operative part only. The first is the
28.
Page 28. And 29, my lord. Current 29. First is the rate of interest. It's
okay. No.
29.
You are challenging the compensation.
Compensation under
What is the ground of challenge?
One is for rate of interest, my lord. Quantum.
Rate of interest.
Rate of interest.
How
It
much
is
was awarded?
4%. It will be 6%.
And second?
Second is that, my lord, income of the victim, my lord.
Okay, income of the victim, how much it was
Income of the victim, my lord, with the evidence was laid and it was averred that it was 10,000. The victim was a owner cum driver of a commercial vehicle, my lord.
So, was the driving license exhibited?
The driving license exhibited, the RC registration certificate of the victim, the vehicle owned by the victim was exhibited.
Of a commercial vehicle?
Of the commercial vehicle, my lord. Is that certificate?
How much income was considered by the trial judge?
5,000, only 5,000 rupees. And your lord, I am covered by a judgment of your lordship where only driver has been given 10,000 rupees, and the judgment I also covered. Obviously, I am also covered by the judgment which your lordship has followed by the latest Supreme Court judgment passed by Honorable Justice Dipanka Datta, my lord. My lord, kindly come to page 54 of the paper book, my lord. Exhibit 7.
Yes.
Santosh Rai, my lord.
This is the vehicle registration.
Vehicle registration. And thereafter, my lord, page 56 is his driving license.
Yes.
And 57 is the vehicles authorized to driving. There is LMV with gear.
No, this is authorization letter.
No, the vehicles, the backside of the driving
Okay,
license, which
okay.
is on the next.
Authorized to drive which vehicle?
Authorized to drive which vehicle, my lord. And my lord, from 54, it would reveal that it is also it is a commercial vehicle. Page 54. Class of vehicle.
It is registered as commercial vehicle.
My lord, it is 11D. It is
Light-
I
light goods
personally not
vehicle.
light
Light goods vehicle. Okay, okay. A goods vehicle cannot be personal purpose.
11D. What my personal knowledge is that 11D. Since I live in Howrah, 11D is for commercial vehicle.
But goods, nobody will purchase goods vehicle for personal use.
Goods vehicle, personal. Commercial vehicle. So, owner income of the owner plus income of the driver. And my lord, he has considerable number, 6 number of dependents, so that at the time of 6 maintaining 6 dependents, owning a good vehicle, so his remuneration plus profit of the vehicle, my lord. So 10,000, my lord, is.
So what is the evidence of PW1?
PW1, my lord, it is PW3, my lord. Kindly come to PW3, which is a widow. PW1, he has given evidence, but it is not so clear. PW3 is a widow, my lord. Page 17 to page 19.
Page 17 to page 19.
Page 17, last at the bottom, I say that at the time of accident, has my lord got it?
Yes, 10,000 per month.
10,000 per month, deeply placed.
And in cross-examination?
Cross-examination, my lord, there was denial, my lord. Then on the next page.
Page 19.
Page 19, bottom, my lord. Koilashra is of denial, but no contradictory evidence was like, my lord.
Yes, what do you say?
And my lord, one thing, one more thing, my lord. One thing two things I missed out, my lord. One is that as regards there was no non-pecuniary loss, which is now 84,000. But my lord, in the judgment I am citing on the Justice Datta's judgment.
No. Question is pronunciation says 70,000.
70,000. There was.
Yeah, it can be enhanced to 84,000.
84,000.
So pronunciation is 80. How much was awarded by the trial court?
No, nothing.
Oh, that is not awarded.
That is not awarded.
So is this your ground of challenge?
Yes, it is also ground of challenge.
Yes, what do you
And
say?
another thing, my lord, 1 lakh rupees, there is the unproved medical document. As per Rekha Jain, my lord, it is not.
How long he was in hospital? How many days?
The 3rd February accident occurred. 6th he died.
3 days he was in hospital.
3 days.
So medical bill was
Medical bill, sir,
not
it is
exhibited.
not exhibited. XY series, my lord, at page 19.
So 3 days he was in hospital.
3 days in hospital, my lord, considering.
Anyway, what
No,
you say?
private hospitals. Private hospitals,
Yes, what do
considering
you say?
this.
My lord, regarding income, my lord, cited one decision of Justice Dipankar Dotto, recent decision, 10,000. My lord, I have nothing to say. Future prospect, my lord.
How about future prospect is considered by the trial judge?
Future prospect regards 5,000 rupees.
No, 10,000.
Okay, you give your calculation.
My lord, regarding medical document, my lord, not proved, not exhibited. Your lordship, this is death case, not injury case.
So 1 lakh he has claimed for medical.
Yes.
But not proved.
Not proved.
So it can be some notional because 3 days stay in hospital, some notional 10,000 or 20,000 at best.
And it is private nursing homes in serious cases where the patient has admittedly died. What I most with all humility
No,
propose.
but discharge
that-
hospital certificate you have not exhibited. No, not discharge certificate.
the
Death
bills could
certificate.
not be paid. There is a voluminous bills, my lord, 10,000 rupees per into 3 days, my lord, 30,000 days, which I propose subject to your
Anyway, give
lordship.
your calculations. Please see the calculations.
আগে অ্যাড করো এখানে এখানে অ্যাড করো ছয় লিখো না শুনে রাখো।
Yes, record an order. Learned advocates for the parties are present, hard learned advocates. The appellant before this court were claimants in a case under section 166 of the Motor Vehicles Act 1988 and are aggrieved by the judgment and award passed by learned additional district judge special court passed by learned special court come additional district judge Hooghly in MSC case number 163 of 2013. Stop. The case of the claimants before the learned trial court may be summed up thus. On 3/4/2013, Santosh Rai, since deceased, was proceeding by a taxi bearing number WB-19 capital A-8432 in a rash and negligent manner with high speed, and when he reached at Bali toll tax area police station Nischinda Howrah, he met with a motor accident endangering human life and safety, for which Santosh Rai sustained severe injuries on his person, and he was admitted to Sunflower Nursing Home, where he died on 6/4/2013 at about 1:25 a.m. Stop. The driver of the aforesaid vehicle drove the vehicle with high speed and in a rash and negligent manner. Stop. The victim was aged about 26 years and he was a businessman by occupation and he used to earn rupees 10,000 per month. Stop. The claimants have been suffering from financial and mental pain due to premature accident of Santosh Rai. Stop. Pursuant to filing of this case, notice was issued upon the opposite party. Although opposite party vehicle owner appeared but did not contest the case till final hearing. Stop. Opposite party insurance company contested the case by filing written statement. Stop. Issues were framed and evidence was adduced. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose of the claim case by observing and directing as follows. এখান থেকে হ্যাঁ, hence it is ordered থেকে page 28-29 learned acha the appellant's claimants being aggrieved by the judgment and award passed by the learned trial judge has come up with the instant appeal. Stop. Heard learned advocate for the claimant's appellants and learned advocate for respondent number 1 insurance company peruse the evidence adduced and materials on record. Learned advocate for the appellant submits that the learned trial judge erred in considering the monthly income of the victim as rupees 5,000 when, although the victim was a driver and documents with regard to driving, namely the registration of commercial vehicle in his name and the driving license was proved before the trial court. Stop. Learned advocate further submits that the learned trial judge erred in not awarding the medical expenses incurred during the victim's stay in hospital prior to his death. Stop. It is also submitted by the learned advocate that the interest awarded by the trial court, yes, trial court should be at least 6% per annum instead of 4% per annum. Learned advocate appearing for the insurance company. I'll record your objection. Yes. Disputes the submission of learned advocate for the appellant's claimants. Upon considering the facts of the case and materials on record, it appears that
income, may I cite these two judgments, but one of your lordship and another the the judgment of your lordship is that page last page.
Yes.
Of your lordship's judgment, my lord, that the last page, my lord.
A learned advocate for the claimant's appellants relies upon the following judicial decisions. Number 1, V. Patmabhati and others versus Bharati A, capital X, capital A, General Insurance Company Limited and another. Reported in 2026 within bracket 1, T capital A, capital C, 705 SC. The decision of Cholamandalam MS General Insurance Company Limited versus Dipali and others. FMA 462 of 2025. High Court, Calcutta.
In Supreme Court decision, my lord, paragraph 16, page 709.
Page
709. Para 16. Last line of para 16, monthly income of the victim accordingly.
Last para?
Last para. Para 16, last line. Accordingly, for the purpose of recomputation, the monthly income of the victim is to be reckoned as rupees 10,000.
This is with the, okay. At the time of delivering this judgment, the Supreme Court judgment was considered. Yes, which page?
No.
As your lordship's judgment, Supreme Court judgment was
No. Hey, tribunal.
No, Supreme Court, it was in 2016, 26.
No, in my judgment, was the decision of Supreme Court considered?
Yes.
In your lordship's judgment, it was considered.
Vegetable.
In the, upon hearing the learned advocates and considering the facts of the case and the materials on record, it appears that the claimants were able to prove the driving license of the victim as well as the registration of commercial vehicle in his name. Stop. As the claimants were able to prove the occupation of the victim.
Correctly, it was not considered.
Yes, anything?
It was not considered. While passing judgment of your lordship, it was not considered. I stand corrected.
Supreme Court judgment is para 16.
Para 16.
আচ্ছা লাস্ট লাইনটা কি বললাম বলুন তো it is necessary to consider the income, monthly income of the persons in the said occupation. In considering the monthly income of a particular categories of employees, courts can consider the income which is provided under the Minimum Wages Act or the income in general of the persons of such categories. As the victim was not employed under any person and it was his own business, there was no scope to apply the Minimum Wages Act. Thus, considering the price index, the nature of occupation, and nature of occupation and the income which is earned in such occupation, the monthly income of the victim could have also been assessed at rupees 10,000 as claimed by the claimants. In the case of V. Padmavati and others versus Bharati A capital X capital A General Insurance Company Limited and another SUPRA, the Honorable Supreme Court observed as follows. Para 16. In the case of Cholamandalam MS General Insurance Company Limited versus Deepali and others, it was observed as follows. Page 7, second paragraph. আমি ইয়ে করে দিচ্ছি দাগ মেলে in the event the monthly income of the victim is considered at rupees 10,000, the annual income comes to rupees 1,20,000. 40% of future prospect added, which is 48,000. The total annual income comes to rupees 1,68,000. 1/4 should be deducted on account of personal expenses, and the net annual dependency loss comes to rupees 1,26,000. By applying the multiplier of 17, the total dependency loss comes to rupees 21,42,000. Stop. Further, the claimants are entitled to get rupees 84,000 on account of loss of consortium, loss of estate and funeral expenses. Thus, the total compensation comes to rupees 22,26,000 by arithmetical calculation. However, as the victim was in hospital for 3 days, it would be reasonable to add rupees 25,000 and award a reasonable compensation of rupees 22,50,000. Hence, rupees 22,50,000 is the compensation which the claimants appellants are entitled to from the opposite respondent number 1, insurance company. Respondent number 2, insurance company. Hence, this appeal FMA 114 of 2021 stands disposed. The judgment and award dated 28th July 2020 passed by learned additional district judge, passed by learned special court cum additional district judge Hooghly in MSC case number 163 of 2013 stands modified to the extent that the appellants claimants are entitled to compensation of rupees 22,50,000 from respondent number 2, insurance company. Stop. The respondent number 2, insurance company shall deposit before the Registrar General High Court, Calcutta, rupees 22,50,000 along with interest at the rate of 6% per annum from the date of filing claim case till today. Stop. Such deposit shall be made within 8 weeks.
Already paid order amount.
Yeah, just such deposit shall be made within 8 weeks from the date of communication of this order. Stop. In the event the compensation awarded by the learned trial court is already deposited, the balance amount be deposited. Stop. The claimant's appellants are permitted to withdraw the compensation amount upon compensation of necessary formalities.
And in equal share.
No, whatever is there in the trial court, that has to be followed.
That also may be indicated, madam. So
withdraw
unless
the
it is not
compensation
indicated-
upon compliance of necessary formalities as per the share mentioned by the trial court.
Oh, then no, my lord, there will be another difficulty, my lord. One thing, my lord, because one of the appellants has died, my lord. So that is then the trial court, the department will, we have to come again. with
Acha,
your
tale
lordship.
in equal shares.
In equal shares, my lord, it will.
That means widow and 2 children, or only children.
Children and widow, and one parent. Two parents were there. One of the parents died. So now in equal
Okay, so let it be equal share.
Equal share it will. And one more thing, my lord, it is 2% will be on the 2% on the deposited amount. Till
No, I have stated entirely 6% uniformly.
Deeply.